Since I have been mentioning repeatedly here, my lord.
Extension of interim order, please wait. Extension of interim order, please hand over the slips, mentioning when it is going to expire. Any other extension of interim order? Please hand over the slip. Please mention when it is going to expire. Applications, please hand over the slip.
Application, my lord.
Listed motion.
Listed motion.
Listed motion. Please mention the urgency. Hand over the slip. Hand over the slip.
The urgency, my lord.
Yes, please.
This is which we did but the matter could not be taken up.
What do you want? Included.
Included in this.
Why? It was in the list. It has not appeared where it was listed before Justice Basu.
But the second week was not 2 days.
So it was in that list.
For that, before the expired, the honorable judge released the matter and said, our matter goes back to the record.
Hand over the slip. Son, under what heading? Hearing matters, please do not mention.
My lord.
Non-prosecution. Non-prosecution.
Non-prosecution, hand over the
My lord,
slip.
may I be permitted to mention?
Prosecution, please hand over the slip.
My lord, may I be permitted to mention?
Please wait, madam. Withdrawal, there is, please mention, once the file comes, it will be listed. All right. Give the item numbers then. All right. Then it will be listed. Yes.
My lord, in this matter, I have been appointed as a special officer by Honorable Justice Bishwajit Basu last year, October 2024, my lord. Since then, I have been visiting thrice a week for 2 hours. My residence is in Bali, Howrah, my lord, and the visitation is at Mukundapur, which is 30 kilometers from my house.
You have to travel to Mukundapur.
Yes, my lord.
You are a special officer.
Yes, my lord. The child has undergone surgery, 2 surgeries, major surgeries in the past 6 months, one in October and one in March. That is why, considering the circumstances, it was held that the child will remain with the father. The father has the custody. She will remain as it is there.
Right,
And the
you
mother
mentioned.
Only one.
You are appearing in that matter.
I am the mother. I have been given the visitation rights. Now, only one problem. On last occasion, the learned special officer has through a mail. Has totally he stopped my visitation to my child.
Let it appear under the heading to be mentioned.
The other side also. Yes, yes.
The same matter which you are
Yes,
mentioning.
my lord.
Why are you giving 2 slips? He has mentioned.
Yes, the notice to the other side, I'm just giving that.
All right.
I'm deeply obliged. my
Action
lord.
tag kore din nale dukhana.
Deeply obliged.
Yes.
With my lord's kindly.
Yes, what do you want? Under the heading? Why it is not appearing? When did it appear? April. It is not appearing. Not appearing in the daily list. It's appearing in the monthly list. It will appear in the monthly list. Yes.
With my lord's kindly, may I be permitted to mention this matter, my lord? My lord, the matter has been posted ex parte hearing, and the next date is fixed for framing of issues, my lord. I have filed an application. This is matrimonial suit. I am for the wife. I have filed an application under.
What is the next date fixed?
Next date is on 6th.
Please hand over the slip mentioning the urgency.
6th May, my lord.
You have mentioned the urgency.
Yes, my lord. Yes, my lord. I'm deeply obliged.
Yes. Yes, Mr. Singh.
No, there is a matter. It's a matrimonial matter running in the monthly list. But the problem is here.
What do you want?
I want on application being heard out by the earlier bench, my lord, as a direction been given for meeting the child, 4 years child, which lying with the, residing with the mother. That there. But now every week sending a message that I'm coming today. Next, once upon, I mean, 2, 3,
Matter is appearing in the monthly list.
my lord, it's a very, there's urgency pending.
Mention the urgency, hand over the slip.
No.
Please mention the urgency, hand over the
My
slip.
lord, my lord.
Your Lordship, may I be permitted to mention one matter?
I am the partition defendant.
What do you want?
According to Senate
2004.
Please mention the urgency, hand over the slip.
Your Lordship, may I be permitted to mention one matter?
Yes, for what?
This is a division bench matter, Your Lordship.
Division bench better. Please mention on next Wednesday.
Your Lordship,
Please mention on next Wednesday. Only another day left in this week.
My lord, may
Yes.
I permitted to mention one urgent motion, my lord, against the order of priesthood, my lord.
Please hand over the slip mentioning the urgency.
Lordship, may I permitted to mention a matter new motion?
Hand over the slip mentioning the urgency, madam.
Lordship, permitted to mention, Lordship, for arbitration, Lordship.
Hand over the slip mentioning the urgency. You need not mention individually.
Urgency लिखा, urgency लिखा ना.
My client here, my lord, is going to expire on
What is going to expire?
27 April 2025. My lord, what happened, my lord? My lord,
Please hand over the slip mentioning the urgency.
My lord, may I be permitted to mention one matter for upgradation in the daily list? The petitioner is a
Sir,
senior citizen for
Some advocates are in your front. Please maintain the decorum.
My lord, may I be permitted to mention one matter for,
Let me proceed from that side. Yes. Start. Yes.
I am the petitioner, right?
What do you want?
8 dates have been passed, my cross-examination has not been done. I only pray that my cross-examination, because the opposite party has.
Hand over the slip mentioning the urgency. Yes.
my lord, kind leave to mention one matter. My lord, praying for leave to file my civil litigation application and my
Why leave is necessary?
lord,
No. What is the urgency?
section.
What is the urgency?
22nd, 23rd. My lord,
22nd and 23rd.
23rd of April, I will.
Please mention. No leave.
If I may.
Nothing will happen.
See,
No.
section 15 that order is. my lord, obtained.
All right. Yes. File, then give the number. No leave. Yes.
My lord, I am the petitioner, and the water connection has been disconnected.
What do you want?
I want the restoration of water connection since it.
Hand over the slip. Yes.
Matter for, my lord,
Under what heading?
new motion, my lord.
Motion. Hand over the slip. Yes.
Lordship may be permitted.
Mention the urgency.
If your lordship recalls, this is that matter that your lordship was hearing, if occupational charges can be granted under the West Bengal Premises Tenancy Act. The matter has been stayed and it was.
So it's a hearing matter, madam. Please don't mention hearing.
Lordship, I have had-
contempt
Yes.
application. Contempt 11 December 2024 order was passed. I have communicated the order 3 times.
Hand over the slip. Yes.
Number 171. I am grateful, Lord. I did the keep not make the date fixed and thought. The appeals are pending.
Please hand over the slip mentioning the urgency. All right. It will be considered. Yes. All right. You want upgradation? Yes. What do you want? Hand over the slip. Mention the urgency. Yes. Interim order expired on? Why did not mention prior to that? Hand over the slip of the extension of interim order. Yes.
To mention this matter for correction, my lord. Correction, my lord.
Correction. Hand over the slip.
My lord, I have been mentioning from August 2024. Previously, it was in court 5 and now it has transferred to court 6. So can you just have the upgradation of the
Please
order?
mention the urgency. Hand over the slip.
865.
Please mention the urgency in that
Yes, ma'am.
slip.
I am an old lady and I am about to in the
Sir,
petition.
please mention the urgency. I will consider that.
Yes, please.
Yes.
Thank you, my lord.
Your lordship,
Yes.
this is my
I'm done.
early hearing application. I filed in September.
What is the urgency, sir, in early hearing
The
application?
petitioner is a senior citizen and around 20 days in the lower court, they have been taking adjournments.
All right. Hand over the slip. Yes.
Mentioning for upgradation, my lord. I stated that.
My
Hand over
lord,
the slip.
item number 1473 of the monthly list, your lordship has heard the matter on 17th of March and directed to appear after 1 week, but the matter has not appeared after 1 week. My lord,
Hand over the slip, yes.
6th of May, the date is fixed on the lower court.
Please mention the urgency, hand over the slip. Yes, Mr. Chatterjee.
Compelling circumstances, my lord, this revisional pending this revisional application.
Please,
Pending the revisional application, my lord, the trial court has, my lord, reserved the matter for judgment. My lord, if this is not heard out, my lord, judgment would be passed any day.
what is the nature of the impugned order?
Impugned order is, my lord, at the argument stage, my lord, what happened, my lord, the plaintiffs withdraw the money deposited in
Any
the
caveat is there?
no caveat.
This reserve for judgment, Mr. Chatterjee, is
So
very
today, if my
difficult.
lord allows this revisional application, my lord, then he will be bound to consider my application where, my lord, my defense was earlier.
The other course would be beneficial for the other side. But you have said the other way. I think that will serve the purpose.
No, my lord,
When it was fixed for, when it was reserved for judgment.
my lord, last week, my lord, court has directed me
Mr.
to
Chatterjee, why you
finalize.
did not mention there was
My lord,
a
I
bench?
mentioned before Justice Basu, my lord, Justice Basu brought the file before his court. But prior to item, 10 items were left, my lord, now my lord is back. The file is lying in courtroom number 70.
ওটাকে দিয়ে দিন তো কালকে। কালকে দিয়ে দিন। Yes.
Kindly, Millet, to Millet, obtain leave of your lordship.
Why?
To Millet, the certified, the order has been passed on 11, last Friday, just before the.
What is the grave urgency? You cannot
Millet,
file with the
Millet
certified copy.
Millet section 47 has Millet been disallowed. Millet.
What is the number of the 47 application?
Now, Millet insolvent.
Fourth application, fifth
No,
application?
First application.
Only?
Millet, two prior civil division are already pending before the lordship, Millet. Millet, the issue is here, Millet.
There is no stay.
No,
There is-
insolvent, no, it was not. The insolvency proceeding mandates that Millet, a moratorium is there. Millet, no proceedings can.
All right, hand over the slip.
Millet, may I, Millet, it's Millet, I need a leave, Millet, and move it on Millet to Monday, Millet.
Why? What is the urgency?
The writ has been issued. The writ has been issued on.
What is the date fixed in the writ?
Millet, the next date has been fixed on Millet. 15th May. 15th
15th
May.
May is long time. With the,
Very well, Millet, may I at least.
can file with the server copy, but file it.
I'll keep it.
It will appear in due course. So to leave to file without the certified copy, but with the server copy. Yes, Mr. Pal.
Figure to item number 330, one of the trial, the matter, date is fixed before the trial on 24th.
For what?
For what, my lord, for hearing of the suit. 7 to application.
24th of April. Why did not mention there was a
It
pay?
was appear, well, we expecting, well, that matter will be taken up for that reason, well, didn't mention it earlier.
Mention the urgency, hand over the slip. Yes. Yes. New motion, yes. Yes, sir. Upgradation. Not to send over the slip.
May we permit to mention one matter for upgradation, my lord, expeditious disposal matter. My lord, the petitioner is senior citizen, my lord. My lord, the opposite party is taking dates in the lower court and.
Is there any urgency in expeditious disposal matters?
Eviction suit, my lord, injunction application is also pending, my lord, kindly allow the upgradation.
All right, hand over the slip. Yes.
Upgradation for expeditious hearing, my lord. A petitioner is 80 years of age, my lord, declares that suit is pending since 2000.
Right, I will follow that judgment of the Honorable Supreme Court. I will upgrade all these matters, but I will strictly follow the decision of the Honorable Supreme Court. Upgrade করে এক order এই সব
Past predictions for expeditious disposal, but even after that judgment, Supreme Court is passing.
Supreme Court can pass, Mr. Kormokar, but all right, I will follow that strictly. I will upgrade all expeditious hearing matters. I will follow that decision. Please
kindly consider that the West Bengal housing.
I will upgrade it.
Trying to.
I will fix the
develop the
date.
property, my lord.
I will upgrade it. I will fix the date, but please bring that Supreme Court judgment.
শুধু বলবে bound আছে আমার কিছু করার নেই।
Please bring that Supreme Court judgment. I am telling you. Then please don't mention. Yes.
May I hand over the slip?
Please
I'm
don't hand
mentioning
over the
mentally
slip.
the urgency.
Provided that is the condition, I will put it under the heading to be mentioned tomorrow.
Well,
But you have to bring that judgment.
Write down the urgency, kindly consider, my lord. Well, this is, my lord, West Bengal Housing Board is trying to develop the property.
Lord, kindly grants me leave, Lord, to file without certified copy, Lord, order from the National Commission. National Commission, I have the Supreme Court's judgment, Lord, it has to be filed in the jurisdictional High Court, from where it emanated. So, my lord,
National Commission against that can be moved
Against
before
that,
the
Lord.
Supreme Court.
Lord, if it's a original jurisdiction National Commission is exercising, then Supreme Court.
Yes.
If it's appellate jurisdiction, then Lord, it has to be before the jurisdictional High Court. That is what Lord.
It is the appellate jurisdiction, then
Yes.
it's the power of revision.
Revision. No, that's exactly what I'm. Now, Lord, kindly permits me to file this revision without the certified copy of the state forum.
The state forum.
Lord, National Commission, I have.
Department is insisting that, Mr. Kormoka.
Yes.
In most of the civil revision applications, the trial court certified copy is not there.
Lord, that should be, but I'm surprised they're
That
doing it correctly.
Should be.
That I'm surprised not that doing it correctly.
No, that I appreciate, but I'm asking you, is the department
Yes.
not accepting
Lord,
that
that's the reason why I'm before your lordship, Lord.
in all matters, not in.
Lord, that I do not know, Lord. This is the first time I faced it.
I will remember this in any matter where the trial court's order is necessary in a revision. In your matter, I will remember
Lord, that's
that.
the requirement of the leave, Lord. They are not
That's-
permitting.
Leave to file without the state commission's
State
order.
commission.
Leave to file without the
Lord, state
certified.
commission and district commission.
State
From
and
district commission to state commission, thereafter till national commission. National commission I have. Other two, Lord, the Xerox certified copies I have. The original certified
So,
copies I do not have.
Mr. Kormoka, the National Commission did not exercise the appellate jurisdiction.
Lord,
It has to be the revisional jurisdiction.
Yes, revisional jurisdiction.
Not the appellate. You said appellate
Lord,
jurisdiction.
Revisional
I asked
jurisdiction.
when I
Lord,
said appellate jurisdiction.
Lord,
You
your
said
lordship knows, Lord, revisional jurisdiction is akin to Lord appellate.
against that revision.
Yes. 227 or 226. 227 or 2. I shall try and satisfy your lordship on that. I'll try and satisfy.
I was under the impression you said appellate.
Yes.
But if it's the revisional jurisdiction of the National Commission.
But I shall, Lord,
Kormoka,
try and
leave
satisfy.
the DAP of the district forum as well as the state forum. You have the server copies of both.
Lord, Xerox certified copies I have.
Xerox certified
Yes.
copies.
Because I preferred
Without the
those
certified
appeals.
to file without the certified copy of the district commission and state commission.
Lord, the other one is,
That also leave.
my lord has disposed of this revisional application on 25th of March. Lord, this against me, Lord.
Wrong did I commit?
Lord, your lordship granted us some Lord leverage staying Lord the operation of the execution proceeding. So before, so that I can prefer an appeal before the state commission. Lord, that particular stay is Lord missing from your lordship's order. Lord, kindly, Lord. Your lordship would
Please
recall,
appeal
my
for
lord.
the other side.
Lord, we have served notice, my lord. Shayok Ranjan Ganguly for the bank and Meghojit Mukherjee for the opposite parties. We had served, my lord, the notice. Your lordship would recall this, my lord, just before going, my lord, your lordship had
Yes,
passed.
yes. Paragraph 8 is, I think, clear. Pending of sufficient time, this could pass an eviction order.
Your lordship had granted the stay till 17th of April.
You have not yet filed.
I have, Lord, my instructions. Online it has been filed, Lord, but till because your lordship had passed that order, Lord. If that particular paragraph, Lord.
এটাকে to be mentioned কালকে করে দিন তো। কালকে please inform the other side.
Obliged.
To be mentioned tomorrow or Tuesday.
Tomorrow,
will be
tomorrow.
Obliged. Inform the other side.
Yes, yes.
এটা to be mentioned কালকে করে দিন।
ফোন করে বলুন। WhatsApp করুন। Obliged, Lord.
Yes.
Lordship, kindly to mention a matter, this is an ALP for transfer. So this was heard by the earlier bench of Justice Raja Basu Chaudhary. Now with the change of bench.
Transfer from section 24.
No, it's an ALP, clause 13. Clause 13. Lordship, I suffered, I got an eviction decree, but thereafter when
original side officers are not here. What is the difficulty? It original side. Is there any other side has
yes,
appeared?
contest in the yes, yes.
Please serve a notice or you will come tomorrow.
I will come. Yes, your lordship.
Please come tomorrow at the morning.
Oh.
Kalke to.
Grateful, I will come tomorrow at the morning.
Please
Grateful.
serve a notice upon the
Yes.
other side.
Your lordship for inclusion in the daily list.
Correction, hand over the slip. Yes.
Inclusion.
My lord, under compelling situation, my lord, may I mention this matter, my lord, the debt recovery proceedings, my lord, and order, my lord, there is a 17 application pending. Direction was given to file reply, bank did not give any reply. What is happening, my lord? bank, my lord, made payment to my lord purchase.
What do you want?
Today is the date fixed, my lord. They have proceeded, my lord, under
What-
section 14.
When
my
is
lord.
the date fixed?
Today is the date, my lord. I have instructed my client, my lord, to take somehow time, my lord, before for giving police assistance, my lord.
It is appearing in the list.
Yes, it is appearing in the list.
Monthly list.
Yes.
এটাকে কালকে দিয়ে দিন। Okay, it appeared for the.
No
opposite
caveat,
party.
no caveat.
Yes.
One for arbitration 2005 matter, the suit matter that the person has suffered 60% disablement matter. The suit has been rejected in 2000.
Mention the urgency.
Mention the
So
urgency.
long urgency.
Matter 2005 suit matter.
It shows there is nothing. You have to write so many words for urgency. It shows
There is a palpable, palpable malafide on the part of the insurance.
That is on merits, not on urgency.
Matter the urgency is that.
All right, hand over the slip. Yes.
And matter one.
Well, under
review and
competition,
two,
we are mentioning one
one
matter.
review and two
You are opposing his player.
No. This is something else.
Yes. Yes, yes. So, yes.
Pursuant to your lordship, direction one of the matter was appearing in the supplementary list. There is some urgency before your lordship was there, went to circuit. Mention this matter concerning the urgency that was listed before my Lord Justice Basu, not been taken up. Now I am in soup. But I'll,
It was in the
my Lord's list. It has not been taken. I mentioned concerning the said my Lord Justice Basu was pleased to the matter was running in the list.
What was the matter?
Injunction, my Lord. Injunction in partition suit. Trial court, trial court granted your injunction. Appellate court said you are claiming 14 decimals, so how you are not entitled to get injunction of the industrial suit property. Is honored of the suit for partition. I have to ask for partition. Injunction is in its entirety.
Please mention the urgency, hand over the slip.
That I have already, as well the urgency I mentioned, my Lord, Kali consider it is practically that blocking. Now, my Lord, once they have constructed that, my Lord, again the same thing will happen. It is abided by the result of the partition suit. Once partition suit will continue, my Lord, my ignorance and ignorance has been totally.
I will consider that. Yes.
Extension of interim order. The urgency is there that suit is.
Extension of interim order, when it will expire?
It will expire in December, Lordship.
It has expired in December.
Application is pending.
Application is pending. Hand over the slip. It will appear under the application.
29.
It will appear under the application. Yes. Application. Yes.
My suit for divorce pending before the learned court below.
What do you want?
Lordship, I have filed an application that opposite party.
What upgradation?
Upgradation, Lordship.
Mention the urgency, hand over the slip. Yes.
I pray for inclusion of this matter in the list.
Hearing or motion?
Motion. Filed in January, not yet has not come up.
It has not yet come up.
Come up thereafter.
Thereafter, you paid for adjournment.
No adjournment. It has not come up. Once. Not heard once.
Yes.
My Lord, the urgency in this matter is my Lord.
What do you want? Upgradation?
My Lord, upgradation. My Lord, there is urgency. My Lord.
Hand over the slip mentioning the urgency. Yes.
My Lord, another matter for infusion. My Lord. My Lord, it was due to appear on 9th. My Lord, it didn't appear.
9th
of this month. My Lord, 9th of April. My Lord.
Yes.
My Lord, for inclusion of motion.
Inclusion
of
of
motion matter.
Mention the urgency, hand over the slip. Mention the urgency, hand over the slip. Yes.
My Lord, this is for upgradation, my Lord, the next date before the.
Please mention the urgency, hand over the slip. You did not mention individually.
My Lord, this is for upgradation, but it is under section 24 and the next date of the hearing in Alipur.
Madam, please mention the urgency, hand over the slip.
My Lord, 3rd May, my Lord.
Hand over the slip mentioning the urgency. Yes, call the list. Call the list.
Item number 1.
Yes, Lord. I am for the petitioner.
Yes.
Lord, petitioner is the early hearing of the application.
Of what application?
Order 9, Rule 13. What happens? File a petitioner before your lordship is a landlord and is a tenant. He 2015 defaulter, 2017 suit was filed. The next day, let's say he appeared and filed a written statement. After the said suit was dismissed, execution is filed. After filing the execution, they file an application order 9 Rule 13. That is a stay. Only that way I directed to dispose the next date Yes, my lord.
But the presiding officer has been transferred.
Yes. my
Has the presiding officer joined?
Join, my lord.
Joined?
Join.
When did he join?
Joined in Howrah Court, I don't know.
Then why are you saying that he has joined?
Join, my lord, next date is 19th
That is a
August.
different thing altogether. 14th of January 2025 order is that the presiding officer was transferred and 25th of March was the next date fixed. What happened on 25th of March?
25th of March, then 19th August 2025.
19th August it has been fixed.
Fixed.
Has the presiding officer joined?
Joined.
Has joined?
Joined.
It has been fixed for what?
Fixed for hearing.
For hearing of the
Order 9 rule.
Evidence completed.
Completed.
Evidence completed. When evidence was completed?
I don't know, my lord, evidence not completed.
Sir, you are not sure what happened in the suit. This application under Article 227 of the Constitution of India is at the instance of the plaintiff praying for a direction upon the learned civil judge, Junior Division, 6th Court at Howrah, to dispose of miscellaneous case under Order 9, Rule 13 of the Code of Civil Procedure, being Miss Case number 78 of 2024, expeditiously. First up, paragraph from the order sheets appended to this in view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite parties. First of, however, the learned advocate on record of the petition.
Lordship, this is a revisional application for setting aside the order dated 40, order number 40 dated 2/12/2024. The applicant herein is a Thika tenant, and the opposite party had actually filed a decree for permanent injunction being titled suit number 162 of 2013, along with decree for temporary order of injunction and ad interim order. Your Lordship, I have inherited the applicant had actually inherited the Thika tenancy from his deceased father along with his brother. Now, in this particular matter, the schedule, if we have been the application has been for the permanent declaration, wherein if we see that we have asked for we had made an application for 151, which can be seen in page number 30 and 31, annexure D, where we have prayed for repair of the Thika tenancy property. Your Lordship, the property is in a dilapidated condition, and this entire suit has been actually filed for evicting us, wherein we are staying in inhuman condition, and the
The trial court observed that there is no existence of the property And there's also an order of injunction. Where is an order of injunction not to change the nature and character of the suit property?
But the condition in which the order of injunction,
Where is the order of injunction? There's an order of injunction restraining the parties from changing the nature and character of the suit property. And it's a finding that you are trying to change the nature and character of the suit property.
the order of
What is the
injunction
stage of the
is,
suit?
it is in pre-entry hearing stage. Issues have been framed. The order of injunction is annexure C, page 28, running to till page 30.
Where is your application under section 151?
Page 30. Your Lordship, the repairs which I'm demanding, which my client is demanding, is very simple. It's the basic requirement because the property is in a dilapidated condition and it's inhuman in nature. We are not trying to change the nature and structure and the integral part of the property, but just to make it in a human condition for an habitability issue.
Did you apply for local inspection?
We haven't applied for it.
The picture of the suit property is not before the court, and the trial court has found that there is no existence of a suit property. What I can do, I can expedite the hearing of the suit. You can remain in the suit property in that condition for a few days.
Your Lordship, this entire matter has been filed just to evict me. They are trying to make the livable condition in such a manner that I cannot stay. The water is seeping in my property. I'm very
Then
poor.
find out a different accommodation. It's very difficult for you to stay in that property.
My client is very poor. He's barely surviving.
This is a finding that you are trying to change the nature and character of the suit property. This application under Article 227 of the Constitution of India is at the instance of the defendant and is directed against an order being number 40 dated December 2, 2024, passed by the Learned Civil Judge Junior Division, First Court at Shialda, entitled suit number 162 of 2013. The petitioner hearing filed an application.
Your Lordship, if I may just interrupt, in my original application, that is section 151, before the learned court, I have annexed all the photographs of the property where the inhuman condition is there.
You have not taken appropriate steps prior to filing of an application for repair. Kyola? Under section 151, paying for repairing of the suit property. Paragraph. The learned advocate appearing for the petitioner submits that the suit property is in a dilapidated condition, and unless the petitioner is allowed to conduct the is allowed to make the repairs as specifically stated in the schedule of the application under section 151 of the Code of Civil Procedure, the petitioner will suffer irreparable loss and injury.
Your Lordship, if I may just add one more submission, if possible. Your Lordship, the interim relief which has been granted under the interim order, it's already a final relief. It's already in the nature of final relief.
Which
because
order?
the interim relief which has annexure C, it's already final in nature.
That you have not challenged. That order is not under challenge. First up, Kyola. Loss and injury. Paragraph. Record reveals that the learned trial judge, by an order dated April 20, 2021, allowed the application under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure on contest, thereby restraining the defendants as petitioners hearing from making any construction over the suit property. First up paragraph, the learned trial judge, while considering the application for repairs, took note of the submission of the learned advocate, took note of the fact that
There's a counterclaim in a suit. The suit has been withdrawn.
Number 3.
There was a counterclaim in a suit. I am the defendant. Defendant counterclaim. The suit was withdrawn. The counterclaim was not proceeded with.
Suit was
withdrawn by the plaintiff.
Yes.
Counterclaim was not proceeded with.
Why?
The counterclaim has to be proceeded. That I do not know, my lord. We were there. We pointed out to the honorable court, learned court below, my lord. There was a counterclaim. I'll just show indicate, my lord.
Was your counterclaim registered as a separate suit?
No, my lord. Counterclaim was there.
Sir, you did not apprise the learned trial judge of the provisions. Counterclaim also has to be registered as a separate suit.
That is what should have been made. That was the.
You have not also pointed out that what should have been done. And your counterclaim,
court fees were there.
your counterclaim is a part of your written statement.
Counterclaim has been, it's a part of my written statement. It's a separate. Court fees were paid separately.
Maybe
court fees were
has to be a separate full cost title. It is just like a plain.
It's like cross suit, my lord.
Yes.
The cross suit. That's the
so a separate number. There is a division bench judgment of our court. I am a party to that decision. It was directed to be circulated.
None of the courts follow that. That's the difficulty.
We are also not apprising the courts to follow that.
This
is the result of that. If the main number goes, How the counterclaim will proceed now? Under what number?
That is the difficulty. That is the
That is
procedure
the
that was
difficulty. You
followed.
did not point out.
Procedure was followed for a long time, my lord. This is an old procedure. My lord, suddenly, my lord, this procedure disappeared. My lord. Some, my lord, we don't know what has happened. You know, this was registered as a, this was not registered as a
Where is the order withdrawing the suit?
It's in the certified copy, my lord.
Where is your counterclaim?
Sure, I'll indicate. But the order is it, my lord, 22-125. 22-120 in the certified copy. Last 3 pages, my lord.
22-1-2025.
The order dated.
Order dated
22nd of January 2025. In certified copy.
22nd of January.
That's
Yes.
the order. That's the order.
You are also not present on that date.
We were present. Hajira was there, my lord. We appeared. My lord. It was not recorded. It's also a trial court thing, my lord. Trial court doesn't record
Sir,
that.
please place the first sentence of the order dated 22nd of January.
Today is fixed for draft copy publication and show cause by the principal. We filed a show cause as well.
When did you file show cause?
That day.
It has not been recorded.
Not been recorded. Just it was withdrawn.
You did not oppose that also.
Well, we opposed. We told the report that
nothing is on record.
That is
Show me that you have said you have opposed.
how will I show that I said?
From the revision application, your statement on oath.
That I can
Your mere statement from the bar. Nothing on oath. You have stated that this submission was made. You can say many things from there, but nothing on oath. Who will take the responsibility of these statements of yours? No, nothing on record, nothing on affidavit. And you are also subject to correction, not there when the matter was moved. How can you say so? You are not, you did not move
I
that.
didn't personally go there.
So,
Junior was there.
So,
but he has appraised the court. There is a counterclaim as well. This was appraised to the court.
the revision court cannot say what transpired in
I'll
the.
kindly make it not today. I'll file a supplementary. Not there. I'll bring it up. Just
For the petitioner, my lord, praying for not today, my lord.
Why?
Because the senior is not available today. This is some emergency, my lord. He is not appearing in the court.
This application under Article 220.
The defendants are the petitioners before my lord in a suit for
Yes, yes, give your name. Yes.
In a suit for declaration and injunction, an application under order 26 rule 10A has been allowed. My lord.
Yes.
The impugned order is at page 118.
Yes, what is the suit for?
Declaration and permanent injunction.
Where is the application for under order 26 rule 10A?
That is at page 97.
Page
97.
97.
Annexure J.
Where is the plaint?
Yes. Well, plaint starts at page 19. But I must point out, my lord, I find that the entirety of the plaint has not been properly in the first, but I have the entire copy.
The entire copy of the plaint.
Well, the opposite, the defendants, who are the petitioners, have a mine. The plaintiff alleges that the blasting being carried out in the mines is damaging the suit property. I have two major points for opposing this order, my lord.
Yes. What is the difficulty?
Only 2 points. Firstly, I've challenged the maintainability of the suit.
That is a different
That
thing
application
altogether.
is pending. That application is pending, and without deciding that issue,
If the suit is dismissed, everything will go. So,
my lord. And another, the reason for challenging the maintainability is because the
mentality is a different thing. What is your challenge? What is your
absolutely no reasons, my lord. No reasons.
what?
In the order, impugned order, there are no reasons, my lord. We have filed a written objection.
What is your written objection?
My lord, the reason,
Points can be decided without without the scientific investigation.
my lord,
The points.
why the maintainability point is important. The plaintiff had
Mentality is a different thing altogether.
decided, yet appointed a committee. It has directed the.
When is the application for mentality fixed? Hearing on the point of mentality fixed? That will be decided. Nothing to interfere with this. If the suit goes, it goes. Everything will go.
But if my lord kindly sees the order, there is no reasons, my lord.
I can supply the reasons. I will supply the reasons. The
My lord, I am for the petitioner, my lord. This is a suit for declaration and injunction, my lord. Title suit 1319 of 2022. My lord, kindly come the impugned order, my lord, 10/2/2025.
Yes. You are challenging the order, vacating the order of ex parte hearing.
Ex parte hearing, my lord.
Why? You don't want a contested hearing.
Yes, my lord. On
Your
15
case is not good on merits.
No, my lord. On 15/5/2024.
Fight it out on a
No,
contested
no,
hearing.
my lord. On 15/5/2024, my lord, the defendant first appeared, my lord, and asking for the copy of the plaint and the injunction application, my lord. On the same day, the copy had been served. Thereafter, my lord, several days had been passed. They didn't take any step. My lord, on 10/2/2025, again they filed a written statement and ex parte vacating petition.
Yes.
They are not properly interested, my lord, to contest the case, my lord.
What is the suit for?
Suit for declaration and injunction,
What
my
is the
lord.
declaration sought for?
Declaration in the respect of the, my lord, this plot of land, my lord.
That you are the owner of a plot of land.
Yes, my lord.
Better if it is on a contested hearing.
My lord, the interim order, ad interim
Where is the
order has
so-cause
been.
petition? Where is
My
the
lord,
so-cause
yes, my
petition
lord.
filed,
Yes, my
which was
lord.
filed on
Yes, my lord.
10th of February 2025?
Yes, my lord. My lord, annexure P5, my lord, first.
Page?
Like there are some problem in the designation, my lord. And first, my lord, annexure P4, there is a Bengali petition, my lord, that was filed on 15/5/2024. Thereafter, they didn't take up any step, my lord. And after that, on
Where is the
10/2/2000.
so-cause petition which
My
was
lord,
filed?
on annexure P5, my lord.
P5, what is the P5? P5 is the written statement.
Written statement, my lord. Thereafter,
So-cause
the
petition.
show. Thereafter, my lord, the ex parte vacating petition.
Where is that page?
My lord, there is some problem in the pages, page designation, my lord.
All right, I've got that.
And after that, my lord, written objection in respect of Order 39, Rule 2A application.
What is the miscase for?
My lord, miscase is Order 39, Rule 2A, my lord. On the plot of land where the interim, where the injunction was granted, my lord.
Was served upon them?
In the year 2022, my lord. 2022, the summon has been properly served, my lord. Thereafter, they didn't appear. They received the summon, my
That's the
lord.
order showing that summons was served upon them.
My lord, that order has not been annexed here with my lord. Then I will file the supplementary affidavit in respect of that order.
Not necessary, madam. Yes, Asha.
My lord, they had received the summon, my lord.
Expediting the suit. This application under Article 227 of the Constitution of India is directed, is at the instance of the plaintiff and is directed against an order dated February 10, 2025, passed by the Learned Civil Judge Junior Division, 5th Court of Howrah, in title suit number 1319 of 2022. So by the order impugned, the order fixing the suit for ex parte hearing was vacated. Good stuff. Vacated, and the written statement was accepted subject to payment of cost. Civil Procedure Court settled.
Even my lord, in this matter, have instruction to appear to opposite party, my lord.
Yes, what is this matter?
My lord, by the impugned order, my lord, learned judge below, my lord, rejected the prayer for, my lord, using the secondary evidence. Although my lord, all the ingredients of section 65, my lord, has been, my lord, said, placed
A
before
copy
the.
to Mr. Bhattacharya. You could have written a letter to him. This matter appeared on 26th of March.
Difficulty was I was not aware, my lord. Subsequent, we have also lodged a caveat subsequent to the filing of revision. Thereafter, we came to last Friday itself, came to know from the court below, learned advocate court below, they have filed a revision application immediately.
Intimated before the learned court below that is
all right. When this matter is taken. Yes.
Lordship, in this matter, Lordship, the defendant's case is based on complete falsehood, Lordship. Because Lordship,
What is the impugned order?
Lordship. Kindly see at the last page, Lordship.
Yes, where is your application under section 151?
Lordship, preceding Lordship, which is also annexed at the last page, Lordship. Number was not.
Yes. What is the submission?
Lordship, the defendant's case is completely based on falsehood.
Prove that by way of evidence.
Lordship, in this matter, when the defendant at the initial stage, when made false and which is clearly ipso facto proof, this is a false and forged document. Then the Lordship, for this reason, petitioner, plaintiff Lordship made an application to the trial court because the ipso facto, this information, false information and false documents ipso facto clearly
Have you laid any evidence with regard to this?
Lordship.
Have you laid any evidence with regard to this?
Lordship, these documents actually stated by
way of evidence.
Lordship, these documents actually stated by the defendants in their written statement.
Challenge those documents, that is forged documents.
I have challenged, Lordship. I have challenged before.
Prove those by way of evidence.
I have proved, Lordship. I have submitted.
Pass an order. Pass a decree in your favor.
But Lordship, this was rejected.
Cannot be in an application under section 151.
But Lordship, may I submit, Lordship? Kindly give me opportunity, Lordship. Because Lordship, the Honorable also Supreme Court clearly held in a series of the decision, Lordship, when any of the parties make false and which is ipso facto prove that this is falsehood, Lordship, I said. Lordship, I made Xerox copy, Lordship. Kindly allow.
Yes.
It will be summarily thrown out. At any stage also proceeding, Lordship. It was said by the because Lordship, falsehood cannot stand because they vitiate the judicial process, Lordship, at this stage. And I also can show, Lordship, before your Lordship, how the defendant vitiate the judicial proceeding by submitting false information and false documents, Lordship, because the false document is clearly proved at this stage, Lordship. I also can submit, Lordship, if your Lordship allow me.
What?
because Lordship, that false information and false documents submitted, the person who did not given the power of attorney by giving his name, the transfer the property, and which is clearly arise from their documents, Lordship. If kindly see this document.
Prove that in the evidence. Why are you shying away from proving that those facts in the evidence?
No, Lordship.
What is the stage of the suit?
This is stage preemptory hearing, Lordship. Preemptory hearing.
You are the plaintiff.
I am the plaintiff.
Your evidence has started.
Evidence has not been started. Before that, Lordship, I have
fixed for filing of the affidavit in chief by the PW1.
29th of April, Lordship.
File that, prove that.
But Lordship, it is when it is clearly proved at this stage, then that the Lordship, when the
cannot be proved,
no,
whether a
Lordship,
document
the
is
issue
forged or not, that cannot be proved by way of an application.
The trial is, Lordship, only my prayer, Lordship, trial is going on because if there is disputed fact. But when this
there is no dispute with regard to this, according to you, it's only based on false.
No, Lordship, but the defendant actually did not deny this in the which is also stated in their in the order, Lordship. Did not deny the content.
Take advantage of that admission in the at the time of evidence.
But Lordship,
take advantage of that admission. You can take advantage of that admission.
Advantage, but at
that admission, of that admission, you can take advantage in the evidence also. There's a procedure laid down in the evidence.
There's a procedure, but Lordship, when this is
take advantage of that.
This is a Lordship completely not only this is a completely false. This is a criminal conduct, Lordship. But
initiate a criminal proceeding. Initiate a criminal proceeding. I'm not stopping you from initiating.
But Lordship, by showing this false document, if the defendant want to proceed and try to make defense of this case, then it will be also
no.
Deceive the justice system, Lordship.
That it is false and forged document.
It is proved at this stage, Lordship. I am showing also. If your Lordship kindly allow me, I will show, Lordship. It is also ipso facto proof.
Sir, I cannot from here say which document is false or forged or not.
Lordship can consider, Lordship. Lordship can consider. If your Lordship allow me, Lordship can consider at this stage because it can be arise at any stage of the proceeding.
Then your suit has to be stayed. Has to be stayed. I cannot allow your application. Reject their written statement without issuing your notice to them. On the other hand, I can expedite the suit, prove those facts in the suit. You get a decree right now.
Lordship, I have a right. I am approaching before the court. But Lordship, when the defendant clearly made the false information and which is subject to arise from their statement and also documents, whether the defendant can get right of defend this Lordship suit, because the defendant is subject to make false at this stage.
Show me that they
Lordship,
false
Lordship, I am saying. Lordship, kindly see page number.
Where is your plane?
Lordship, kindly see page number 12, Lordship.
Yes.
I also I have.
Where is your plane?
Lordship, this application has been given under order 39, but
rule 1 and 2 is not the plane. Where is your plane?
Lordship,
show me your plane.
Same fact has been stated. Also, Lordship,
where is the decree which you have paid for in the suit?
Lordship, I am submitting, Lordship. Kindly allow me, Lordship.
You have annexed the written statement,
Lordship,
but you have not annexed your plane.
Lordship, I will submit. If your Lordship permit, I will also submit.
What are the prayers in the plane?
Lordship, this is the declaration and permanent injunction because the petitioner father first purchased the property from Akbar Ali Mullah. Kindly see para number 1, Lordship, where it has stated that the father of the petitioner purchased the property from Akbar Ali Mullah, and thereafter, after passing of the father,
Sir, I cannot decide the suit here. I cannot decide the suit here.
I am not saying, Lordship, but only my prayer to that extent the defendant made fraud and false information which arise ipso facto from their statement. For the reason I am coming. Lordship, kindly see page number, Lordship, the statement of page number 20, which is stated by the defendant. I am reading only, Lordship. Answering
the basis of your claim is in the application under section 151. These are the points. You can place your points in 151. You need not place all the documents which have been annexed. Please place 151 application.
Lordship, in their written statement, only the defendant.
Not in the written statement. Show me your application under section 151.
Lordship, which is annexed in at the last page, Lordship.
Yes.
Where may I read, Lordship?
Yes, yes.
No, Lordship. Lordship, where it has been clearly stated, the new fact made by the defendant number 1 and 2 in their paragraph number 15 of the written statement, where the defendant 1 and 2 stated that they have purchased the part of the suit suit plot demarcating from the recorded owner by 3 separate deeds. Deed has been which is stated by the defendant Lordship, and became owner and possession holder of the suit schedule property. In this context, plaintiff submits the plaintiff collected copy of the registered sale deed. Lordship, I have collected registered sale deed. Wherefrom it appears, after going through the registered sale deed, it appears from the registered sale deed, the defendant not purchased from the collected registered, defendant purchased by way of power of attorney. Power of attorney also part of the record, Lordship. And from the power of attorney, it arises that Akbar Ali Mullah, from whose he saw that Akbar Ali Mullah sold this property, but Akbar Ali Mullah did not give in their power of attorney, did not sold his share or any part of his share, did not transfer his share. But in the registered sale deed, it has been shown that Akbar Ali Mullah given. I am showing Lordship. Lordship, Lordship, my first prayer, Lordship. May I submit, Lordship?
Yes, yes.
Lordship, kindly, my first prayer, Lordship, kindly come to page number 27, Lordship, where it is sale deed. Sale deed has
Sir, I
been.
cannot decide from here whether the sale deed is forged, false and forged.
Lordship, because Lordship can only decide when the forged document, false information at this stage, if so back to come from their statement. For this reason, I am praying, Lordship. If this is a disputed question of fact and law, then I cannot raise, Lordship. But at this stage, this false information arise. For the reason, I am praying before Lordship.
Anything more?
Lordship, may I submit, Lordship? I will, if your Lordship allow me, I will submit my prayer one by one, Lordship. If your Lordship. Lordship, in their purchase deed, it is clearly stated at page number 27, Lordship, where it has been stated, Lordship, I am reading, Lordship, at the last para. The name of the Akbar Ali Mullah has been given, Lordship. Akbar Ali Mullah, they says the Akbar Ali Mullah and other person given this land by a power of attorney. And they first said that they purchased from the Akbar Ali Mullah and other person, where it has been stated that they purchased the property by way of after getting the power of attorney. If I have also annexed the power of attorney, where it has been shown that Akbar Ali Mullah did not give or refused to execute the power of attorney. And it is clearly evident from their record, Lordship, because this is a part of the records. Kindly see page number 79, Lordship. Kindly see page number 79, where the Akbar Ali Mullah clearly refused to execute this power of attorney. But the defendant says they purchased the property from Akbar Ali Mullah and others, but Akbar Ali Mullah did not give and did not given this power of attorney holder their share. So how they purchase the property? This is a completely false documents, and ipso facto, Lordship, at this stage, this false information. For the reason I am appealing before it.
Thank you. Ashok, this application under Article
Lordship, before going to the impugn order, for divorce, I am the wife respondent. Lordship, let me the court allow this thing that in terms of section 24 of the Hindu Marriage Act, Lordship, this application as the misproceeding shall not abide by any other fate of the divorce.
No, what is the order impugned? What is the order impugned?
Lordship, the husband has filed a suit
For
now
divorce?
for divorce under section 30.
Yes.
Simultaneously, we have filed an application under section 24.
Yes,
Now,
claiming alimony pendente.
Alimony pendent flag.
Yes.
Now, Lordship, when the application, and because this application has to be required hearing first, so I have served the copy as per the order of the Honorable Court. Now, Lordship, when they have received this copy, they, Lordship, they quit from this contesting the suit, and for that suit has been dismissed for default. Now, the Honorable Court, Landed Court has dismissed my application.
Has been dismissed for default.
This suit has been dismissed for default. There is no doubt in it. Now, my application has been dismissed on the ground. This already suit has been dismissed. But what is the purpose of section 24?
Sir, you ought to have rejected at the time the suit was being dismissed for default. If it has been dismissed for default, what can be done now?
Now, Lordship, what is the purpose of section 24?
I appreciate that, but you ought to have rejected, ought to have objected at that point of time that I have accrued some right. Now it has been dismissed for default.
In my presence, I have appeared in this application to move this application on the miss case section 24.
Sir,
Can
the court compel a party to proceed with the suit? What can be done?
Suit I have not Lordship here before, because my misproceeding section 24 also has been dismissed for default in my presence.
Mukherjee, I appreciate that. But even if it is restored, what will happen?
No, Lordship, I am before your Lordships only in respect of the miss case, not before.
I am on the miss case.
Because what
even assuming
yes.
this case is restored,
yes. Now,
what will happen? Can it proceed
yes.
without the suit?
Now, Lordship, the section 24 purpose is whatever compensation I have incurred in the suit, whatever the compensation, that has to be reimbursed by the instance of the plaintiff husband. That is the purpose of section 24. Section 24 is not that the suit is dismissed, so my right of miscase is also dismissed.
That is one way of looking at it. You could have also objected that first the alimony till that date is to be paid. All other things what you are saying. But once it has been dismissed, can you get this relief thereafter after the suit is dismissed?
Because this
you have an authority on this, Mr. Mukherjee. I think I cannot make yourself clear. I am on a proposition. Yes, I accept what you are submitting, that the husband cannot be allowed to withdraw from the suit during the pendency of an application under section 24. Yes. Miss case. That is absolutely no dispute with regard to that proposition. Yes. But I am on another proposition. After the dismissal of the suit, can this miss case continue? Please satisfy me on that.
Now, only
do you have any authority on that? After the suit is dismissed, good, bad, indifferent, can this miss case be allowed to proceed?
Now, Lordship, the
other proposition which you are citing, I fully agree with you, but that could have been done keeping the suit pending. Mr. Mukherjee, a party, if he wants to withdraw the suit, ordinary cases cannot be objected to. But this is an exceptional case in a matrimonial suit. If a proceeding miss case under section 24 or 36 of the Special Marriage Act is pending, should not be allowed to withdraw before deciding the miss case. But once it is dismissed, can you say my miss case should proceed?
Lordship, kindly
because this miss case has to arise from a suit. After the suit is dismissed,
kindly
can the miss case proceed?
Kindly go through section 24 along with me, Lordship. Where in any proceeding under this act, not only the suit, even section 9 is filed, then I am entitled to.
No dispute.
It appears to the court that either the wife or the husband, as the case may be, has no independent income. Lordship, here is the satisfied.
Mr. Mukherjee, I am not disputing that. But show me, Mr. Mukherjee, please show me. After the suit is dismissed, miscase can proceed.
Lordship,
Show me that.
my-
I'm not disputing for a moment that you don't have any right till the suit was pending. And he also cannot be allowed, the husband also cannot be allowed to withdraw from that suit without paying the alimony till that date. Nothing, because the miscase has, I'm not for a moment disputing that. My question to you is whether after dismissal, good, bad, indifferent, for whatever reason of the suit, whether this miscase can proceed.
Lordship, that,
Coming back after 5 minutes, please satisfy me.
Lordship, that can be, Lordship, because let me serve the copy, Lordship, kindly fix the date.
Please satisfy me at the first stage. Thereafter, I will direct.
Lordship, may I come back tomorrow?
Yes. Mr. Bhatt.
So kindly come to the impugned order,
Yes.
14th January 2025.
14th.
January 2025.
Yes.
Today is the fixed for hearing of the petition dated 1st October 2024. Now next.
What is that petition?
This
First of
was, this was the miss case, section 24 application.
No. What was the petition dated 1st of October 2024?
That is the petition of miss case, section 24.
That is section 24.
Expert hearing, sorry, expert.
Say so. Cannot be because it is in miscase it has been.
Yes. Now,
petitioner files Hajira in view of dismissal dated past in the
yes,
miscase is also
petitioner
dismissed
file
for
Hajira.
default.
So when petitioner file Hajira and appeared,
would not have been dismissed for default.
Dismissed for default. So this
I
is the,
follow that.
It's a technical lordship, but this is the observe the dismiss for default. Now, lordship, kindly come. Just I am reading section 24, one line. That
Hindu Marriage Act
expenses.
আছে? Hindu Marriage Act. Central Civil Act টা আছে? Central Civil Act টা?
Order the respondent to pay the petitioner the expenses of the proceeding. Expenses of the proceeding means whatever the proceeding I have continued, that expense has to be reimbursed by the petitioner. That is the instant of the husband. What he hearing here,
So Mukherjee, the difficulty is the first part of section 24, where in any proceeding under this act, so there has to be an existence of a proceeding under this act. In that, then if it appears to the court that such and such has no independent, it may on the application. So this application, the precondition is there has to be an existence of a proceeding under the act. That is why, Mr. Mukherjee, I am not for you a moment disputing your right, not even expenses. You are also entitled to alimony with effect from the date of filing of application till the date of withdrawal or dismissal, whatever it might be. Not only the expenses, but if the main suit is dismissed, there is no existence of a miscase of the matrimonial suit or a proceeding under this act, whether this miscase thereafter can proceed.
No, so kindly come. It may. It may. Also kindly for my sake. It may on the application of the wife or husband.
Yes, Mr. Mukherjee, it may, but it starts with where in any proceeding. So proceeding, existence of a proceeding has to be there.
Now, what the expenses of the proceeding? Whatever
Everything,
expenses I have
Mr. Mukherjee,
incurred.
everything, not only expenses. You have a better right even to get alimony, not only the expenses only. You have allowed this suit to be dismissed for default.
No, dismissed for default because the husband didn't turn up.
You have objected. Where is the order dated 14th of January 2025?
Kindly come. I have also.
No, yes, the passed in the matrimonial suit. Where is the order passed in the matrimonial suit?
Yes. Also, this is the object of the husband not to give any maintenance. Kindly come page 54, D 54.
54. Mr.
for the keep.
Yes.
Malad,
Mother,
Malad, the learned,
But for
Malad, I'm paying for 2 weeks accommodation, Malad. The
why?
Malad, learned advocate on record could not come to court due to her illness, Malad.
on the last
He
occasion.
gave
they
birth the
also-
child, my lord.
And showing that matter is pending in the list, they took adjournment, that matter is in the argument stage in the trial court. They took adjournment. On the last occasion, they also prayed for adjournment before your lordship. Mother did not took the part of the proceedings of the probate proceeding. Now mother died. After 5 years, daughter came to be added as a party.
An accommodation has been prayed for on the ground. It has been adjourned.
Well, 11, my lord.
But not affected.
I am appealing for the petitioners.
Yes,
Well, otherwise, again it will call, I should not be there. Well, kindly make it on Monday.
So today it will not be called.
Today, nahi, tomorrow.
Yes, next.
It will not be called. Not only today.
Yes, next.
My lord, whether 26 of the Hindu Marriage Act provides any maintenance for the major child.
After all, it's your child, Mr.
Yes, that can be, that is something else.
Don't take those technical points.
Not
After
technical,
all,
that is a substantial point.
the opposite party may not be your wife, but the child is yours.
If
you may deny your wife. Please don't deny your child.
Deny your, why will not be effective? One can consider what is the
age, Mr. Rai, of the son of your son?
Man, can you turn
the age? Please tell me.
19 or 20?
20. So he has independent income. He can maintain. And a father, Mr. Rai, is taking this.
That is something else. Man, for the purpose of education, I am bound.
Yes.
I'll provide.
Not for the purpose of pudding.
Now, that is what the court has held. The 26 enable the courts to pass an order for maintaining the major child also. Whether it is there in the center or not.
Ultimate conclusion is right.
Man, can you consider?
Sir,
if this is the law, whether it is the law, I put this question to myself. Man, can turn to internal page 4.
What is the date of the order?
Beg your pardon, my lord.
What is the date of the order?
Date of the order?
You have given the certified copy. 3rd of October.
3rd October 2024.
After certified copy, what are those photocopies?
Photocopies?
Out of October. After this, why these photocopies, Mr. Rai? No, not photocopies, typed copies.
Oh, because in the impugned order there are some handwritten. The impugned order was
visible.
Handwritten. Now, my lord, if the certified copy consists of any handwritten order that requires to be typed, irrespective of fact whether it is subject matter challenge or not.
Yes.
Now, man, can consider internal page 4. Whether the maintenance under section 26 of the Human Rights Act can be granted to an adult child. My lord, got it? Bold letter. And it was held, it is applicable.
Yes. Relying upon a judgment of a high court.
High court, my lord, I am armed with the judgment of this honorable court. Division bench. My lord, can you consider that? After that,
To a larger bench. I'm
My
referring to a
lord,
larger bench, Mr. Rai.
then my lord, can you consider after that, your lordship can.
Mr. Rai, for the purpose of education, it has been.
I have not education. I have admitted. My lord, can you consider entire examination? I have admitted. I have admitted what the education. I have already paid throughout last 19 years. I'll continue the same because it is my duty to see my child has been probably brought up. Now, my lord, the
So ultimate conclusion is right.
That 11,000, my lord, can you consider 11,000?
11,000
No one can go.
is in class 12. No. After 12, what is
MBA.
after all? Your son will be an MBA.
After
you don't want your son to be an MBA.
I want, but according to my capability, I have to provide my son. And my lord, can you consider another thing? From the date of filing of this application, this has been granted.
Understand the capacity of the client, looking at the advocates, number of advocates he has.
Don't we judge a book by its cover?
Number of advocates.
Judge is a book by its cover. Huh.
Number
Now-
of advocates he could engage in a civil division matter.
My lord, probably have already forgotten our status when the appellate state advocates are concerned doing civil practices. My lord probably knew that full fee. The story of full fee. Can I explain the same before your lordship?
Days have changed, Mr. Rai.
Days have changed, but practice remains the
That
same.
much I can say.
Practice remains the same. So for which you have learned from our.
Let us go to the matter.
Only one thing, my lord. These are the one point. Another point is, my lord, it is admitted fact she is earning something. But I'm not on that.
The wife. So it's only for the son which has been directed.
No, wife. Both.
So opposite party is directed to pay for studying higher education of Shom Shah, the son of the petitioner.
And opposite party has maintenance.
Opposite party earning, how you could not.
That is not,
You could
and
not
from the date of application, my lord, kindly consider to be. Now, my lord, date of application, your lordship can consider when it is the date of application, whether there is attribution on my part to delay the proceedings. My lord knows. If any attribution on my part to delay the proceedings.
Mr. Rai, there is a decision which has taken a divergent view.
But yes, but something must be there.
Was in some manner responsible for that, but in that matter, facts are completely different. Otherwise, it's the law that it is to be from the date of the application. And in some cases, 1997, volume 11, I think on 9 SCC, there is a decision which says either from the date of application or from the date of order, if the parties have suppressed their income.
Yes.
So it's a discretion. So here the code has
why the discretion has been exercised, my lord, can you consider?
With regard to the from the starting point of the date of application, that discretion has rightly been exercised.
Well, discretion has to be exercised judicially. Well, where is the attribution on my part?
No. Mr. Rai, it's not that
I have paid
responsible for the delay. It should not be from the application. It's the other way around. If the wife was responsible in that decision, he will be finding.
In other ways, is that if the husband also causing some impediment.
If the wife, after filing, so that fact was something different. Otherwise, it's the general law that general rule that it has to be from the date of the application. May not be. I accept your submission that you are not responsible for the delay, but it has to be from the date of the application.
And 26 Malad can consider whether it can be done or not. Whether Malad can modify the order, the reasoning is something else, but whether this 26 can be attributed for the purpose of granting alimony to a major child.
I think Rajneesh versus Neha has.
Rajneesh versus Neha, Malad, there is the production of the entire documents. Not only that, it will continue after maintenance to all spare. I could have understood Rajneesh versus Neha has been considered in that way. There's no deduction from filing of assets and nothing.
But Mr.
I'm not also taking into account all these things.
Yes.
But whether Malad, the
But I think Rajneesh versus Neha also dealt with this issue of minor child, major child.
Yes, but
Son also.
Son also to what extent, my lord? Here is a specific.
Do you have that copy of that decision?
That I can bring. But
I think
section 26, my lord, whether it can be permissible. I can understand
that. I'm leaving that point.
No, my lord, I have invited lordship to decide this.
Considering the fact that
Then, my lord, now, my lord,
11,000 only, what are you doing?
Yes, what I am doing, I am poor businessman.
Businessman, all businessmen are
Not poor, my lord.
All
So I am not
businessmen are
going
poor.
to that aspect. Whether 11,000 is
What is the finding of your income in the
nothing?
in the order impute?
Nothing. First allegation is 1 lakh. After that, 50,000. The court is of the opinion 50,000. But
So I've seen the nature of the business which you are carrying on.
Land.
Very, no. Page 2. Page 2. Very profitable business, Mr. Rai.
Yes. My lord, if you logically consider my objection.
What is the date of filing of the application?
Yes, date of filing of the application is 24.
What is the stage of the suit?
That will be February 2024. Yes.
I can expedite the suit, you pay off the alimony. I think that will be beneficial for your client. What is the amount of arrears?
That
What is the stage of the suit?
Stage of the suit, my lord.
Evidence.
Next page, your lordship, the order dated 30th January 2025.
30th January.
Vacant. That is why for hearing. I do not know what here. Next page, my lord, lordship will find the order subsequent to that. The court is vacant. No further progress has been made, probably.
8th of April for hearing.
Yes.
So it's hearing matrimonial suit. It
No,
has
no, no.
diverted to the stage of hearing.
It cannot be.
Why?
Because the earlier order, your lordship, this miscase was disposed of.
Yes.
Subsequently, my lord can consider the order there 4th October 2024. Next order. At the bottom. Certified copy at the bottom.
Yes.
My lord, got it?
Yes.
PO is on leave transfer for hearing.
For hearing, then it was adjourned since the
court is vacant.
Court is vacant. It was date was fixed on 8th of April.
Yes.
What is the area amount? Can you come back with instructions? What is the stage of the suit? What is the
and the area? What is the area?
How soon can you liquidate that? I can expedite the suit.
And indicate that so it is benefit for mine too.
All right. Next week, Mr. Rai, or tomorrow?
Yes.
Next week.
Monday, my lord, tomorrow I don't know whether communication is restored or not. Because these are all Murshidabad. My lord, it's very difficult.
Mr. Rai, only one thing I can record that, but recording means I have taken a final opinion.
Yes, my lord is not interfering with the order.
I have not said that till now. I am only directing you to take instructions.
Yes,
I am not recording anything. I am only keeping it. Please take instructions on that. After some argument.
Lordship, item number 12, Mr. Dheeraj Kumar Trivedi. Mr. Dheeraj Kumar Trivedi, he went to Vaishno Devi. He is out of station, your lordship.
Very
I am
short,
praying for not this week, your lordship.
very short point. An arbitral award was passed in 2017. I filed an section 34 application before the commercial court at Howrah, Barashat. A stay was granted. It was continuing. And all of us.
Section 34, section 5. How it is?
Section 34.
Yes.
No, not 5, not 5. Section 34.
No. It says that submits the application.
No, I'll tell.
Has not been annexed to this
Yes,
application.
I'll tell. That is not. Section 34 filed before the Barashat court. Stay was granted. It was continuing for 2-3 years. Suddenly, the commercial courts act came into the picture, and the matter was transferred from the commercial from Barashat court to
commercial
court at Rajarhat without a notice to me. I was not informed.
Dismissed.
It was dismissed for default by the commercial court at Rajarhat. I filed a restoration application after 3 years. I came to know after almost
with that section 5.
Yes. And I filed a restoration application. The learned commercial court at Barashat recognizes the fact that I was not informed of the transfer recognizes that fact. It's indicated. And despite that, dismisses my section 5 along with the restoration application.
Section 5
This is all that is there.
Yesterday, last week, they have given a supplementary.
No, it was on Mr. Dheeraj Trivedi's request that I should bring it that on
He's
record.
out of station. He went to Vaishno Devi. Lordship, kindly consider, just not this week, your Lordship, I'm praying.
Let them not proceed with the execution. That's all I'm saying.
I cannot.
That has to be.
That
If you are
is
paying for
something-
time, you cannot proceed. with the
Something has to be.
Kindly, please
That-
consider, your Lordship.
Two things cannot proceed. If you are paying for accommodation, yes, but you should not proceed making this revision application infructuous.
My lord, let Mr. Dheeraj Trivedi come, your
You
lordship.
should, madam, please don't proceed
My
with
lord,
it.
give me then short passover. Let me talk to him over phone, your lordship.
Come at 2 p.m.
Yes, your lordship.
Come at 2
Deeply
p.m.
obliged.
Take
I will.
instructions.
I will. Lordship.
Then the execution, what is the date of execution?
They have already taken an order for filing affidavit assets.
You should not proceed with the execution.
Lordship, let me
in the
take the
meantime.
instruction. 2
Yes,
p.m.
please come at 2 p.m.
Yes, sir.
Yes.
13.
Yes.
At number 13, I am appearing for the petitioner, lordship. This is my application. The suit has been filed by the opposite party husband, praying for a nullity of the marriage, lordship. The hearing was, the evidence was going on. The opposite party has been examined in chief in full, and then subsequently, my right to cross-examination, the opposite party number 1 has been closed by the learned court, lordship.
Why?
Since it was, may I just place with 3 dates, lordship? The examination in chief has been concluded on 5th of July 2024. Then the next date for cross-examination was fixed on 5/9/2024, lordship. On that date, due to I am being ill, I prayed for an accommodation for that date. The prayer was considered and it was allowed. And then on the next date, that is on 14th of January 2025, when I again made an application for time.
Why are you praying for time on repeated occasions?
Lordship, only thing is that I am a lady, lordship. I am suffering from some illness, lordship. That is why we are.
But haven't done 7th of April. You are appearing for the opposite party.
We were not served the copy yet, my lord, and
no intimation of lodging any.
we shall find an opposition.
What opposition, sir? The
I am-
opportunity, what is the next date fixed?
6th
I will
of May,
allow
lord-
them to cross-examine on that date itself.
Lordship.
What is the next date fixed?
6th of May, lordship.
6th of May. It has been
6th of
fixed
May.
for cross-examination.
Lord, no,
So for
May-
further
Milord,
evidence
for
of the
further-
PWs.
Milord, I
After this, no PWs have
no, they have
no
not
affidavit
filed
has been
any
filed.
affidavit.
So I'm allowing them to cross-examine your witness.
Milord, every time they are praying for adjournment.
That is
more-
only one
Only one
opportunity, last opportunity.
Lordship, as well, lord.
Ashok,
Lordship, may I just only one humble prayer,
please
lordship?
give him a copy.
Lordship, I shall. By
Not
course
shall.
of by
You
course of
don't have an
this day,
extra copy.
lordship,
Give him in course of this.
I will
day.
in course of the day. And only thing, lordship, I am humbly praying that if 2 dates may be given.
No. Then I was rejecting. One day you have to conclude that.
I leave
No
it
2
here,
dates.
I leave it here. Since my right and my defense will go, I am praying for only 2 dates. I will conclude my entire.
You have, sir, you have
cross-exam-
repeatedly taken adjournments. You have repeatedly taking adjournments.
Case is
Complete
pending
it on
from
one day.
2019.
My lordship, it's pending
Yeah.
till 19. Since 19, it's pending. The case is pending.
2019.
2019.
Yes.
I leave it to you.
Ashok. This application under Article 227 of the this is a matrimonial suit.
Yeah,
Matrimonial suit for nullity of marriage, lordship, filed by the husband. I am the wife.
This application under Article 227 of the Constitution of India is at the instance of the wife and is directed against an order number 27 dated January 14, 2025, passed by the Learned Additional District Judge, 5th Court at Balashat, District 24, Koganas North, in matrimonial suit number 146 of 2019. So, stop by the order impugned, the right of the petitioner hearing to by the order impugned, the cross-examination of PW1 was closed on the ground that was closed after rejecting the prayer for adjournment at the instance of the wife slash petitioner hearing. First of paragraph, the learned advocate appearing for the petitioner submits that what was the reason why you prayed for time on that
It was
day?
due to illness, Lordship.
Illness of whom?
The opposite party, Lordship. Sir, the
Petitioner.
The petitioner, wife.
The learned advocate appearing for the petitioner submits that on account of illness
Petitioner's
of
wife.
the
Petitioner's wife.
Wife.
The wife.
Yeah.
Wife is the petitioner.
No.
Wife is the petitioner here. In the
Yes.
suit, she is the respondent. In the defendant. In the suit.
Yes. So the wife's prayer for adjournment was
done.
of the wife slash petitioner hearing. The an adjournment was sought for by the learned advocate for the wife in the matrimonial suit. First of paragraph. Taking into consideration the fact that the suit is a matrimonial suit and an adjournment was sought for on the ground of illness of the wife petitioner hearing. This court is of the considered view that a last opportunity should be given to the wife petitioner hearing to cross-examine the PW1. First up, তার আগে একটু যেখানে পিটিশনের সাবমিশনটা বলেছি না তারপরে একটা লিখে দিন the learned advocate appearing for the opposite party vehemently opposes the prayer of the petitioner. First up, he submits that the suit is of the year 2019 and the petitioner is trying to drag the instant matrimonial suit. ঠিক আছে, তারপরে considering the fact বলে যেটা হলো সেইটা প্যারাগ্রাফ দিলাম
14, I beg to appear for the, my lord, the landlord. My lord, your lordships may recall, this is a mall in Howrah, my lord, and the petitioner before your lordships, my lord, was having a kiosk at the mall. And my lord, the term sheet, my lord, which is the agreement for license that expired after 11 months. Thereafter, my lord, we sought to, my lord, evict the occupier of that space.
What is the order impugned?
My lord, the order impugned is, my lord, vacating the injunction on, my lord, evicting the petitioner before your lordships without, my lord, any due process. My lord, my client appealed against that impugned order, which is dated, my lord, 18th of September 2024 at page 52. 18th of September at page 52.
Your client preferred an appeal.
I preferred an appeal. My lord, one of the grounds in appeal was that there is an arbitration agreement between the parties.
You have challenged for what?
Lordship, it is my application. My friend is.
And my lord, in the meantime,
Allow him to submit.
my lord, only one thing, my lord, that they have vacated the premises thereafter during the pendency. My lord, on the last occasion, yes.
Yes.
Lordship, on the other day, this has been prayed that the petitioner has vacated the premises. Pursuant to this submission, the Lordship was pleased to direct by the next very day to submit any documents to substantiate their claim that the possession has been made over. Perhaps this is not done.
But I have, my lord, the gate pass, and my lord, I have video recording from the CCTV of the mall,
and the video
which
recording.
shows, my lord, that the, my lord, the petitioner is vacated.
All right. Yes. What is this matter?
Lordship,
What are you
the suit was initially for a declaration of tenancy, and
what is the order under challenge?
the order it is
Page 71.
in the operating portion.
Page 71.
12th of March. What happened on 12th of March?
Your lordship,
the order
page
date-
71.
uh, 12th of March. Or the internal page is the page 3 of the order impugned. It appears from the termination clause of the term sheet that there is a condition of issuing 15 days notice in case of non-observance of any term and condition. But in this case, the agreement has terminated by efflux of time, and there is no condition of notice in this matter. In case of any dispute, the court must go to the arbitrator as per the arbitration clause, and by signing the term sheet, the proprietor of sweet and salt, Otonu Baswal, agreed to that. Considering the documents, it appears that according to the agreement between the parties, the present plaintiff respondent have to go to the arbitration, otherwise it must delay. Lordship, the first thing is this: the arbitration clause is to be adopted, adhered to in the learned trial court. Whether there has been an arbitration clause or not, and it is section 8 of the Arbitration and Conciliation Act. Section 8, power to refer parties to arbitration where there is an arbitration agreement. 1, a judicial authority before which an action is brought in a matter which is the subject of the arbitration agreement shall, if a party of the arbitration agreement of any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute, that notwithstanding any judgment, decree, or order of the Supreme Court or any court, refer the parties to the arbitration unless it finds that prima facie no valid arbitration agreement exists. Lordship, the first precondition is an application under section 8 has to be filed before the learned trial court. Firstly. Second,
No, it has not yet been referred to the arbitrator.
no, not had been applied to. First thing.
Not yet referred to. What is the ground of challenge of this order? Why are you challenging this order of
So
12th of March?
The learned first appellate court has been pleased to hold that we must go to the arbitration.
But no direction has been passed for that.
Yes, sir. The direction is there.
Where is the direction that you have to apply before the arbitrator? No direction has been passed. Ordering part, only the order of injunction has been set aside. Nothing with regard to the arbitrator. There is
Ordering that the misappeal be and the same is allowed on contest as per the observation made in the body of the order. The impugned order authority shall let a copy of the order along with the LCR is sent to the Court of Learned Civil Judge Junior Division Vidhannagar for information and necessary action. So, sir, the scope for application under Section 8 has not been kept open. So it is this, and see the other thing is this, I have categorically challenged the term sheet. See, in as much as there has been a first round of litigation, wherein in the first...
Yes, have you applied under Section 8?
My lord, not yet, my lord, but however, my lord,
How could
my
this order be set aside on that ground?
my lord, kindly observe, my lord, in the appeal, in my appeal, I have taken a specific ground
Yes.
that the learned single judge, my lord, did not consider that there is an arbitration agreement, and my lord, the
Maybe, but
plaintiff
you have not applied under Section 8.
No, but there,
You apply
like,
under Section
as your lordships has rightly observed, my lord, there is no direction in this impugned order for going for arbitration. Now, my lord,
But that is
my
the
lord,
ground for setting aside.
my lord,
the-
because my lord, the learned judge could not have passed an order of injunction when the arbitration agreement was in place.
Why?
My lord, because it's an ex parte
You
order.
have not applied under
But there's
Section 8.
there's an ex parte order. I have not been given a chance, my lord, to place my case. And my lord, there are judgments, as your lordships are very well aware, my lord, even in an affidavit of opposition, if I take a stand that there is an arbitration agreement, that is good enough. An application under Section
The
8 is not
application for injunction is pending.
Yes, my lord.
You
That
file an objection, opposition, take all points there.
Yes, my lord. And my lord,
Will
kindly
give us
also
that
observe, my lord, that they have vacated willfully. My lord, they vacated the premises.
All right.
We have not vacated.
Yes, my lord. I have the, my lord, the gate pass where, my lord, they have stamped and they've taken away all their goods.
This application
No, nothing.
227 of the Constitution of India is at the instance of the plaintiff and is directed against an order dated 12th of March 2025 passed by the learned additional district judge first court Barrackpur in miscellaneous appeal number 102 of 2024. Stop. By the order impugned, the learned judge of the first appellate court has set aside the ad interim order of injunction dated 10th of September 2025 passed by the learned trial judge. First of paragraph, the learned advocate appearing for the petitioner submits that there is no, according to you, there is no arbitration agreement.
Yes, there is no arbitration agreement.
The learned
And
advocate
in
appearing
as
for
much
the
as Lordship, we have
the
taken
learned
the plea.
advocate appearing for the petitioner submits that there is no arbitration agreement.
In as much as the agreement, if it contains this is a dotted line agreement as contemplated by.
Sir, I'm asking you, is there any agreement? Whether it's a dotted line or not dotted line, that is a different thing altogether.
There is an argument, but I have challenged this.
The learned advocate appearing for the petitioner submits that there is no valid arbitration agreement between the parties. First up, he further submits that the opposite parties herein have not yet filed any application under Section 8 of the Arbitration and Conciliation Act 1996, and the learned judge of the first appellate court was thus not justified in setting aside the ad interim order of injunction passed by the learned trial judge. First up paragraph, the learned advocate appearing for the opposite party submits that there exists a valid arbitration agreement between the parties. First up, he submits that the ad interim order of injunction was passed and the opposite parties did not get any opportunity to disclose their defense in the title suit. First up, he further submits that in the meantime, the that the petitioner has already vacated the suit property. First up, paragraph. After going through the order dated 18th of September 2024, this court finds that the learned trial judge, after perusing the documents placed before the court, was of the view that the plaintiff's petitioner hearing is in possession of the suit property. First of the learned trial judge further noted that no one should be dispossessed without any due process of law. In the light of the aforesaid factual finding, the learned trial judge passed an order of ad interim injunction restraining the defendant/opposite parties from dispossessing the plaintiff from the suit property without due process of law. The opposite party herein preferred a miscellaneous appeal against the aforesaid ad interim order of injunction, and the learned judge of the first appellate court, by the order impugned, allowed the miscellaneous appeal, thereby setting aside the order passed by the the order of ad interim injunction passed by the learned trial judge. First up, it is not in dispute that till date no application under Section 8 of the Arbitration and Conciliation Act 1996 has been filed. First up, the learned judge of the first appellate court the learned judge of the first appellate court held that the petitioner hearing has no prima facie case only by observing that the petitioner has to go before the arbitrator. First up, Section 8 of the Arbitration and Conciliation Act 1996 gives power to the court to refer the parties to arbitration where there is an arbitration agreement if any person claiming through or under him applies before the court for referring the matter to arbitration within the time limit specified in Section 8 of the 1996 Act. First up, as observed herein before, no such application has been filed by the opposite parties herein. First up, this court accordingly holds that the learned judge of the first appellate court was not right in holding that the petitioner has failed to make out any prima facie case and has to go before the arbitrator. First of all, for such reason, this court is inclined to interfere with the order dated 12th of March 2025. First up, accordingly, the same is set aside. First up, the learned trial judge is directed to, is requested to, have you filed any objection to the injunction application?
Section 8 application has been filed.
When?
But I am instructed it was 1st of April or 2nd of April.
Of 2025? আচ্ছা, till date না করে এখানে বললাম না আগে বলেছিলাম যে is not in dispute the till date. এখন একটা জায়গায় বলেছি না till date no application. It is not in dispute that till the date of passing of the order by the first appellate court, no application under section. ঠিক আছে? The till date na kore, it is not in dispute that till the date of passing of the order by the first appellate court. No application under section 8 of the paragraph. At this stage, the learned advocate appearing for the opposite party submits that an application under section 8 of the Arbitration and Conciliation Act has been filed very recently. To stop paragraph, in view thereof, the learned trial judge shall proceed in now CO number 1100 of 2025 is disposed of by requesting the learned civil judge, Junior Division Bidhannagar, to proceed in accordance with law.
One first paragraph, Your Lordship, first order of injunction is 10th of September, the 18th of September. First paragraph, Your Lordship, 10th of September, 18th of September.
যেটা ওটা 10th of September হবে না, ওটা 18th of September হবে। ট্রায়াল কোর্টে যে অ্যাডেন্টিম অর্ডার অফ ইনজাংশনটা না 18th of September 2020।
That in view of the fact that they vacated the premises subsequent to
that is the finding of fact. Take all these points. I've only set aside only on that ground that no time is.
should have set aside that order. Then, my lord, the injunction would be back in action, my lord. Then they say that, my lord,
That's I cannot decide whether they are vacated or not. I have recorded your submission.
Lordship, may I only submit that in section 8, subsection 1, the last word is unless it finds that prima facie no arbitration agreement exists.
Yes. Yes, call the next matter.
Kindly
Biblical.
received a phone call just now. I have to rush home. Kindly adjourn my matter. My item number is 36.
Item number
36.
Yes, what do you want?
Kindly adjourn it for this because I received a phone. It's an emergency.
Item number 36.
Of your lordship. I have to rush.
Employee State Insurance Company. এটা একটু মার্ক করে রাখুন, এটা নট টুডে করে রাখুন। None appears for the petitioner at the
My lord, in this matter, husband has come before your lordship challenging the order of alimony pending indicted. My lord, in this matter, my husband has filed a matrimonial suit. In that suit, the wife has filed an application under section 24 of the Hindu Marriage Act. I have filed this objection and I have stated everything. The learned trial judge, without affording any opportunity of leading any evidence, this finally disposed of the 24 application, even without determining the quantum of income of the wife or the husband. And he has, learned trial judge, directed me to pay 5,000 rupees per month without holding my income. My lord, I am a village priest, Purohit. I am a village priest. My income is meager. My 101 or 102 per day. My lord, wife alleged that my income is 30,000 per month.
Village priest is only 100.
Village priest. One per day, per day.
Yes. What he gets. That is the thing which you have said that the cash amount. Other things.
No, nothing other thing.
Nothing.
Yes, my lord.
What are you saying? You have not engaged any priest for any religious ceremonies?
But my income is 2,000.
You don't have to pay anything to the priest.
Yes, my lord. My lord, 2,000 per month is my income.
Actually, they do not have to purchase anything
My lord,
for their daily necessities.
my lord, apart from that, But apart from that,
So have you calculated that amount also? Along with that 100 rupees?
yes, my lord. My lord, apart from that, my lord, I have a paternal property. I have raised a multi-story building through a developer. I have got 5 flats. 3 flats I have given to my wife, one to my wife, 500 square feet flat, and 1 flat to my daughter, and 1 flat to my son. And apart from that, amount of rupees 7,05,000. My lord,
Stay with your wife and son in those 3 flats.
my lord, 7,000, my lord, it is very difficult to stay with her. My lord, that's why I have
Stay
filed
with
an
your son and
application.
daughter.
Yes.
Stay with your son
Well,
and daughter.
son and daughter is not looking me. I have filed an application under section 125 against my son. My son is working.
Filed 125, why?
Against my son for my maintenance. Well, I cannot
Son is
maintain.
employed.
Yes, HDFC Bank, he is doing job in HDFC Bank, but that was not considered.
You proceed. You realize from your son paid to your wife.
Well, that is definitely, my lord, rightly your lordship said, but my lord.
Rightly so, I'm affirming this order.
No, my lord,
observation
kindly
is
send,
right, I am affirming.
I have not given any opportunity to prove my case. But kindly have a look to my objection.
Affidavit has been filed.
Yes.
You have filed your affidavit. What you are saying that you have
Affidavit of asset, not
Yes.
affidavit of asset, not affidavit.
Yes, affidavit of assets. That is only required. What more is
No,
required?
my lord, that is for my lord.
After Rajneesh versus
That
Neha,
is for
what is
interim
more
maintenance.
required?
My lord, that is for interim maintenance, not for the final hearing.
Final
My lord, final hearing.
Have you got the copy of the decision of Rajneesh versus Neha? You are saying that is only for interim. What are you saying?
Including both.
Then
Interim and my lord final. My lord, that is why, my lord, I am submitting that the my lord learned trial judge was to give an opportunity to me to lead evidence to prove the income of the wife. My lord, wife is also earning my lord 12,000 per month. She is
Show me that you have prayed for that you will lead evidence. Show me that.
my lord, 7,50,000 paid.
Show me that you have prayed that you want to lead evidence. Where have you stated that you want to lead evidence and it was rejected? If you have not prayed for leading evidence, what can be done?
No, my lord, this is the hearing. Hearing was done. My lord, hearing only oral hearing was given.
Yes. You have filed your affidavit of assets. Show me that you have prayed that you want to lead evidence. You want to give evidence. You want to come to the witness box. Show me that.
In my affidavit,
Not in the affidavit in chief. Show me that you have filed an application. You want to lead evidence.
yes, I have filed. I have filed an application to give in the trial court. I have
Your
filed.
statement in the revision application. Show me the application which you have filed. Nothing is on record in the trial court judgment.
Yes, it was not recorded, but I have separate one application.
Then I am giving you leave to file an application for review before that court. Since you have made that submission not recorded, file an application for review before that court. That is the avenue open to you, not revision application.
Yes, my lord. I have.
So approach that court with a review application.
Yes.
After some argument, the learned advocate appearing for the Yes, Mr. Das.
I am for the defendant petitioner.
Yes.
The suit is for declaration of, for eviction of a licensee and filed by the plaintiff. In that suit, my lord, matter ends there. Matter, evidence taken, argument was complete. At that stage, my lord, an application was filed. What application? That he want to correct the schedule of the plaint. But only one thing.
2005 volume 13 Supreme Court cases.
No. Here, my lord, argument was complete. My lord, to frustrate, my lord, kindly see. I have also.
Have you brought 2005 volume 13 Supreme
No,
Court?
I brought some other.
Page 89 or 99, whatever it might be. Have you brought that?
Then I will see that I have brought other decision. My lord,
that you are
my lord, other recent judgment of the Supreme Court I have brought, my lord, and also this of at this court, my lord, that amendment after closure of the evidence and after the argument, my lord, cannot be permissible. And my lord, can you say another thing?
I'm well aware of those propositions of law.
I know, your lordship.
Commencement of trial amendment should not be allowed, but there is an exception. If some typographical error of a schedule
2005. Can you
regularly doing this type of matter,
No.
Mr. Das.
Sorry, Mother. 2005, volume 13. Take it on Monday next day.
Then I'm passing orders on this.
No, after that judgment, my lord. But after that judgment, because my lord, here, my lord, can you see what explanation? He should have to satisfy why he has not come due diligence. My lord, can you see the application first?
This argument you are advancing because you have not gone through 2005 volume 30. Yes.
No, my lord, I have not gone through, my lord.
All was considered. So the reasoning was that if that is not corrected, there will be difficulty in executing the decree. Only for that. Only for correction of. Let me go through the order first. Let me see.
And my lord, can you see the application first for amendment? Then your lordship will go through the order. Can you see the application, my lord? I also annexed the evidence. Cross examination, he has specifically admitted that the suit room is on the western side. And on that proposition, my lord, I filed written statement and the trial concluded. This description of property, and if this application filed on an earlier stage, my lord, I could not have said so. But can you see the application? What was the reason under the new provision of the code? Page 38, your lordship will see. No, absolutely no reason. No explanation.
All right.
My lord, can you see page 38?
Page
38.
13.
38. No, that application for amendment.
Yes.
No reason, my lord. Can you see? Absolutely no reason. When the matter is fixed for judgment, my lord, don't file this application. Can you see page 38? Whether the new provision, under the new provision of the code, your lordship knows, my lord, I do not want to argue on that point. Due diligence has to be proved. Reason is to be given. If this is filed earlier stage, my lord, I could not.
Now at 2 p.m. 2005 volume 13 necessitated congener. Come at 2 p.m. Yes, next.
18.
Here, my lord, 72 application.
Yes.
5 revision and application. But order passed on, my lord, on 26th of February. Disposing of an application on the 7/2. My lord, here what happens that your lordship will kindly see the first petition. My lord, I have tendered the rent. She accepted the same up to May 2012. Thereafter, my lord, by postal money order, and after from June 2012 to April 2014, she did not accept the rent for I deposited the rent before the rent controller. The application was filed. Here, my lord, the court was of the view.
Have you deposited this amount?
Everything. But only one thing, my lord, that this order was passed ex parte. I have deposited, it is on record. On record, every challenge are on record.
No, according to you, you are not a defaulter.
No. I have deposited the rent, but only thing, madam, due to
It not appear.
madam, because I was the opinion, another application under section 151 was filed. But I was of the opinion that 151 application to be heard first. Your lordship kindly see the second writ petition, that is page 16. Second writ petition, page 16, I have given the reason. Everything is on record in box. The court did not look into the matter. Certainly, my lord, I am fault because if I could have appeared, my lord, on that date, my lord, the matter could not have been passed. Can you see second writ petition, page 16? Pre-deposit, post-deposit, every challenge are there. That is on record. And 73 application without service of any notice, my defense was stuck up.
Where is your application under section 72?
72?
Yes.
Can you see annexure A, page 7, first of the first one.
Page
7. Can you see the relevant portion is para 8? Para 8, your lordship will see. Para 8 and 9. And challenge I have also annexed.
Where you have annexed?
In the third writ petition. That is 73 defense was stuck up. In that application, I have deposited. Can you see the challenge? That is last annex at page 14. That is CO 723. Your lordship will see.
The applications you have filed. This is the one.
The first one.
Yes.
Second one, application for recalling. That application was rejected. Again, an application for recalling. That application was rejected. And ultimately, 73 was passed without service of any notice. In the last.
Come at 2 p.m. Come at 2 p.m. This is item number 18, 19, and 20.
My lord.
that matter at 2 o'clock, Lordship. See.
Yes.
Lord, Mr. Tribedi Malad is appearing, Lord, in this matter, Lord. My only humble prayer.
No difficulty in adjourning, but you are proceeding with the execution.
Lord,
Should
your
not
Lordship
proceed
may
with the-
kindly, Lord, what has happened, Lord, in this case, Lord, 2014, the award was passed.
No, if you want to argue on merits,
Yes,
okay.
yes, only, Lord, on the last occasion.
Execution, you don't proceed, otherwise it will become infractuous. I can grant you adjournment, plus do not proceed with the.
My Lord, only one humble prayer. Lordship may, my Lord, kindly takes on the last occasion, my Lord, when they sought for time.
No, I did not
saying,
seek for
my Lord,
time.
They wanted a supplementary.
No.
Wanted an application, that is why.
The section five application.
No.
Mail petition, my Lord. It was not annexed to that petition.
It is Mr. Divedi, he does not know. Mr.
Right.
Trivedi only said that it should be brought.
My humble prayer.
Hey.
Last occasion it was
Yes,
adjourned, today it has come up.
Well, only one.
I can grant you, but please don't proceed with the
What
execution.
is going on?
Well, then your Lordship, my Lord, may kindly, my Lord, then keeps it on Monday. Lordship may not passes any order, my Lord, till then. Lordship, if I will verbally, my Lord, because I just spoke, my Lord,
I will record your undertaking.
Yes,
with regard to that.
that's all.
Lordship may not record
That-
my undertaking.
Otherwise, then I will pass an order.
My Lord, your
You have
Lordship,
to take responsibility,
My
sir.
Lord,
Only don't put the court into embarrassment. I will record your submission.
my Lord, only, my Lord, one humble. Lordship may kindly understand, my Lord, in this case, my Lord, what I have been instructed right now by Mr. Trivedi, my Lord, he's right now, my Lord, he's unable to. He's not able to come.
I'm not on
My
that.
Lord, but your
I
Lordship
have
may
no
kindly-
difficulty in adjourning, but the only difficulty is that please don't proceed with the execution. Don't
my
proceed
Lord,
with the
next date is on
execution.
11th of June. 11th of June is the
Yes.
My Lord,
They have
my Lord,
already taken
Nothing
off.
will happen.
Yes.
So don't proceed. So this order will not affect you.
Right.
My Lord, it will, my Lord, in a
Why?
my Lord, because your Lordship, my Lord, this is my Lord, what I'm telling your Lordship over here.
If you
my
say
Lord,
it's of 11th of June,
Yes.
nothing is going to happen prior to 11th of June. So I'm fixing it on Tuesday. I'm passing a short interim order.
Absolutely.
That will not affect you.
Absolutely.
Or I will record your undertaking that you will not proceed with the execution.
we don't have, my Lord, instructions to that to give that undertaking also. It would be
Then let me consider this on merit with regard to the interim order. I can give an adjournment, but execution has to be considered, because if you proceed with the execution, that will be render this revision application infractuous.
my Lord, they have filed a supplementary affidavit, my Lord, enclosing the Section 5 application, which has been, my Lord, served upon us. Lordship may kindly seize, my Lord, that Section 5 application, my Lord, also. Why, my Lord? Because they have, my Lord, what they have challenged, my Lord, before your Lordship.
If on merits, I will consider it on merits. Yes.
Yes.
What is the order and the challenge?
Yes. 102 is the order under challenge. I'll just indicate as to where the learned court had recorded that we were not even served, we were not notified with regard to Lordship sees page 103, second paragraph, third paragraph. In the meantime,
Give me a minute.
in the meantime, by order dated such and such was transferred. No notice regarding such transfer was served on the petitioner, nor any intimation was sent regarding the same. Subsequently, order such and such passed by the learned court, registered such and such. The petitioner had no knowledge of this development. An engaged advocate who represented the petitioner before the Barashat court could not appear due to ongoing. The petitioner only became aware of the proceedings upon obtaining a certified copy of the order dated such and such, which indicated the show cause notice was issued on 20 and the petitioner was required to file a reply. So this acknowledges the fact, and their petitioner was dismissed for default. Lordship will say page 104, third paragraph again, the finding of the court. I'm sorry. Lordship had got that paragraph. It appears from the page 104, third paragraph.
Give me a minute. Page, give me the internal page because I am on the
Page
certified
internal page 3.
Yes, page internal
Third
page.
paragraph, it appears.
No, when the application was transferred.
Lordship is written at 2 paragraphs, Lordship will see.
Give me the dates.
Dates. I have made a short list of dates. Lordship will have it in the petition also. Petition will that. Now, Lordship will see paragraph 15 of my petition.
Give me 3 dates when it was transferred.
Yes. 4th July 2019.
4th July 2019.
Yes.
Section 34 was transferred.
Transferred.
And when it was dismissed.
2nd September 2019. The Learned Commercial Court dismissed the section 34 application due to non-appearance on the part of the petitioner.
And when you applied?
23rd March 2023, the petitioner coming to know of the
3rd of
March 2023 restoration application filed. Delay of 1 to 19 days.
When you what is the date of your knowledge?
23rd March, 13th March 2023.
How you came to know?
That is in the restoration application, Lordship. Restoration application is at page 79. That is from the execution application I have indicated. Page 79 is the restoration application.
Which paragraph you have stated
I'll
about?
just indicate, Lordship, paragraph. Lordship, paragraph 55. 56, 57, 55 onwards, Lordship. Of the restoration application.
What was this miscase of 171 of 2014?
This is the 34 application.
This is the 34.
Which was filed before the Barashat court. Which was renumbered subsequently after it came to the commercial court at Rajarhat.
No, why you said that it was dismissed on 4th of July 2019? No, it was transferred.
It was transferred on 4th of July 2019. I'll only indicate 2 paragraphs, Lordship, from the impugned order.
No, when you came to know which paragraph you have said?
Lordship, paragraph 55. In the order number such and such.
Copy of the order dated. Where is the certified copy of the order dated 13th of March 2013? Paragraph 55, you have said that the
Yes.
certified copy of the
Yes,
order.
I'll just indicate.
Where is that certified
Yes,
copy?
page number 4. Page 63.
63.
Yes. আরে ওই অর্ডারটা বলো না। ওই অর্ডারটা বলো, সবকটা নয়। All the certified copies are annexed. I'll just indicate that particular order only. Okay.
13th of March 2023.
It was applied on 13th of Lordship will see page 63 that we dated. The date is there. Page 63 at the in that.
You applied on 13th of
13th of March 2023.
So it's not the order date.
No, it's applied on 13th of March 2023.
But, paragraph 55 is not.
No, it is not. It is not the order dated 13th. It's applied on 13th of March.
Yes.
May I, Lordship, take your only 2 paragraphs of the impugned order?
Yes.
Lordship will kindly see impugned order, internal page 2 of the impugned order.
Yes.
In the meantime, third paragraph. In the meantime, by an order dated such and such, was transferred to commercial court at Rajarat. No notice regarding such transfer was served on the petitioner, nor was any intimation sent regarding the same. Subsequently, in order number such and such, the case was assigned to the Honorable Commercial Court and registered as such and such. The petitioner had no knowledge of this development, and the engaged advocate who represent the petitioner before the Barashat Court could not appear due to ongoing health reasons. The petitioner only became aware of the proceedings upon obtaining a certified copy, which indicated show cause. Now, next, this is my submission. Now, the finding is at internal page 3, paragraph 3. It appears.
Yes.
It appears that the case was transferred to this court by order dated such and such, and the case records were received by this court on 9th August 2019. In fact, no notice of transfer was served upon either side. This could have been a good ground for restoration of the cases, setting aside the dismissal order, had the conduct of the petitioner being proper all through, and had the petitioner sufficient explanation or delay for the intervening period prior to transfer and filing of the restoration application. This is the only for which the restoration application was dismissed.
Yes, anything more?
Nothing more. That's
yes.
It takes up their application. The civil revision application or thereafter that what they have submitted. Lordship kindly comes to the paragraph number 15 where they have set out the list of dates. Now, paragraph number 15, page number 6. As a Lordship got. Now, let me kindly see, 4th of July 2019, they claim.
Yes, yes.
4th of July 2019, their own case is that the case records were transferred to the learned commercial court at Rajarat without notice to the petitioner.
It's not their case.
But this is their date. It is the date which they are
the list of dates.
List of dates which they are relying on. I'm coming. Why, my lord? Why I'm telling you, Lordship. Document thereafter takes up March 23rd, 2023. What they write.
So, according to you, 4th July was their knowledge. This will be our submission.
They are saying that 23rd March 2023 is when they came to learn about this.
Yes.
Alright, my mark says that is what they have written.
No.
Let's see. The petitioner on coming to know of the March.
The date of filing of the restoration application.
Yes, my lord.
23rd March.
Yes.
When came to know on. Kindly see the petitioner on coming to know of the on 13th of March.
Marks that, my lord. Lordship marks that. Now, Lordship sees the section 5 application.
Yes.
Now, Lordship sees the section 5 application. Your Lordship, because my lord, I'm using my phone, I'm sorry, my lord, I cannot.
Yes.
My lord, may kindly takes up paragraph number 6, which is at page number 8.
Of the supplementary.
Yes.
Paragraph number
6.
Yes.
Page number 8. Lord petitioner further came to learn on the 2nd of September 2019. Second of September 2019 that the missed case of the petitioner by missed case number so-and-so was dismissed for default.
Came to learn on that day it was dismissed.
So then, my lord, no, that is what the pleading is. That no, my lord, they cannot, my lord, take both ways at one piece. Your petitioner further came to learn on so and so, the petitioner was dismissed for default. Thereafter that, your lordship sees. The first paragraph number 3 now, your lordship. What is very interesting, what they are saying. That on 17th of September 2018, paragraph number 3, page number 7, that on 17th of September 2018, the learned advocate for the petitioner fell into serious illness for the problem of his heart. And since September 7, 2018 to 4th of July 2019, he could not take any steps. But there is no pleading with regard to post that in their entire section 5 application that why they could not take any steps for filing this particular dilemma. This is the conduct of these persons in preferring this particular application. This is nothing but a delaying process which they have done. Their own admitted cases is that there has been a delay of 1,250.
Are you ready with the hearing of the main civil division application?
My lord, as far as assisting your lordship goes, my lord, these are the basic.
I'm keeping it on in the next week. Next week. So till that time, please don't proceed with the execution.
But my lord, this is their conduct, my lord, as far as the section 5. My lord, then your lordship keeps it on Mondays.
I'm fixing it on Wednesday.
Well, let it be under the heading to be mentioned, my lord. Since, my lord, they would be, my lord, enjoying an interim order, my lord, after almost 10 years from the date when the award was passed, without them taking any steps for last 5 years.
10 years.
This application under Article 227 of the Constitution of India is directed against an order dated
17.
এসছে বইটা
Here you will will see the application first. I am not on that, my lord. Kindly see, he has to. Kindly see the application, my lord. Then
but
you'll
write on the page number also, page 89.
Page
89.
But you'll also.
Tag yes.
My lord, you'll also will see the application. Nothing, no reason, my lord. And the judgment stage, my lord, the amendment is permissible. At the judgment stage, my lord, kindly see page 18, 38.
38, yes.
Yes. Kindly see the application. The reason has not a single line, your lordship will see. Why 2016 suit has been filed? উক্ত নম্বর মোকদ্দমার এই যে বাদীগণের উপর মোকদ্দমা দায়ের করে উক্ত মোকদ্দমা চলাকালীন
Anything more, Mr. Das?
That is all, my lord. Then you'll also will record my submission.
Yes, yes, I will record your submission.
And also, my lord, to frustrate my argument, this application has been filed. I have written to frustrate, my lord, the argument, points of argument, my lord. After that, record my submission and also the
This application under
You can tell. But here, well, I filed one application on 72 just now.
Yes, what is the other application, which is the most effective, wherein you have produced the challans
Well, that is
or the rent receipt starting from May 2014? Last one.
Last 723.
723 or 723?
723 was start off. 70
How many applications you have filed?
Four applications. Well, last your lordship will see page 14. That is 723. Pre-suit to rent control challans from May 2014 to 2015. Number of 14 challans. And all these challans up to date. And my lord, kindly see my third application where I
page 4.
Page 4?
Yes, page 4, wherein is the list of documents you have produced. Rent for the month of July 2015 to December 2015, 4 challans. How could it be?
14 challans.
No. Second item. Item number 2.
Yes.
July, August, September, October, November, December.
4 challans.
Yes, how could it be? 6 months, 4 challans?
No.
Mr. Das, 6 months, 4 challans.
May 2014 to 2015.
Second item, kindly count the second item.
July.
Yes.
15 to December 2015.
Yes. How many months?
4 challans.
How many months?
July, August, September, October, November, December.
6 months.
6 months.
4 challans.
4 challans.
So, Mr. Das, all challans you have not filed. Next.
In page 3, number 3 application, you also will see my application. That is the relevant portion. Well, kindly see 722. Kindly see page 15 from the bottom. 723. Kindly see.
Where are the challans, Mr. Das?
All on the courts lying in a cover file.
Why you did not? Yes, show me the order.
Which order, Mala?
The order where you filed an application under section 151 for recalling the order. Which matter?
Lordship will kindly see that my second petition, that is CO 721.
721, yes.
Kindly see page 16.
Yes, let me go through the order.
Page 16.
Give me a minute. Give me a minute.
6.
Give me a minute.
Para 5 and 6. Para 5 and 6, page 16. This is my first application for recalling the order. Purely misconception or?
Give me a minute. It has CO 721 of 2025 order record. The application under Article 227 of the Constitution of India is at the instance of the dependent and is directed against an order being number 32 dated 24th of March 2022 passed by the Mr. Das. It was rejected in 2022. And you are filing the civil visa application in 2025.
No, another application for recalling. That is 720.
This also recalling.
Yes.
Why?
Of the both the orders. Of both the orders.
So dilatory tactics. The pure dilatory tactics.
Yeah.
Pure dilatory tactics. After this, you file again an application for recalling.
Of both the orders.
Of what both the orders?
Of both the past application for recalling the order dated 26 February 2019.
Yes, that was the order passed under
That was
section
rejected.
7.2.
That was rejected.
Yes,
Another
but you did not challenge this. It has attained finality.
That is the reason why my application was rejected. That is the reason. And in the meantime, 7C was struck off.
Rightly. Rightly struck off.
I have deposited it.
Rightly struck off.
I have deposited.
Rightly struck off. The deliberate attempt to drag the proceeding.
And I have stated the reason.
What is the reason?
Reason that since I have filed the another application,
That cannot be a ground.
27 April lawsuits in the regulated manner. Timely.
What have you done? After 3 years, you are filing this application. The defense has been struck out, and now you are challenging this order. This order has already attained finality. Then there will be no end to any litigation.
7C order was first recently.
Yes. So this order I am not interfering. Move your 7.3 application. If this order is not interfered with, what remains in the 7.3 application, automatically it was. There's also no requirement to pass any order under section 7.3. Automatic non-compliance has to be rejected. Then
Okay, it's not been sir. That was done by the Alimony.
Yola. Dated March 24, 2022, passed by the learned civil judge, Junior Division, Second Court at Alipur in ejectment suit number 35 of 2015. First up. By the order impugned, the application under section 151 of the Code of Civil Procedure, praying for recalling of the order dated 26th of February 2019, stood rejected. It is the case of the petitioner that he could not file the challans at the relevant point of at the time when the application under section 7 within bracket 2 of the 1997 Act was taken up for hearing. The petitioner claims to have filed the said challan subsequently. And the learned trial judge, by the order impugned, refused to entertain such application only on the ground that there was a gap of more than 1 month in between the date of hearing of the petition under section 7.2 and the date of passing of the order. This court is of the prima facie view that the delay from the date of hearing till the date of passing of the order cannot be a ground. This court is of the prima facie view, cannot be a ground for rejection of an application under section 151 of the Code of Civil Procedure. Petitioner is directed to serve a copy of this application by register speed post with acknowledgement due and file an affidavit of service on the next date. There shall be an order of stay of all
that
Yes.
these applications are early disposal of the suit.
Of what is the nature of the suit?
Suit for declaration and injunction. It was
What is the
filed.
stage of the suit?
Pardon, Milord?
What is the stage of the suit?
Milord, no issue has yet been filed. Milord, no issue has yet been framed also. And Milord, it was filed on 13th of January 2018.
Why SR? Upon whom SR? Rest of the defendants, all the defendants have not been served.
Yes, I have served upon all the
Defendant numbers
respondents.
15
Some have returned. Some have returned.
Some have returned. If the service is not complete, how can a direction for expeditious hearing of the suit be passed? Satisfy the learned court that
three applications are there pending also.
I cannot decide from here. No, what is this service? This is the service of the civil division application.
Yes.
Civil division application I have not directed you to serve. But the fact remains
What
the
they have done,
summons of the suit has not been served.
Milord, the plaintiff has already complied with the Rule 21A of the CPC, and it has been published in the newspaper. Milord, next date is 8th of May. Now,
8th of May for what? For ascertaining whether the service is complete or not.
Yes.
So at that
What
this
happens
point of
in
time,
the
how can a
meantime, I have been suffering the injunction, right?
But that cannot be a ground
2019.
unless the suit is ready for hearing. How can a direction for expedition?
Initially, there were two plaintiffs. Now, Milord, how many lordship can you consider?
Cannot be a
There are one after the other, Milord, amended applications are being filed, one after other. And the last amended
number one.
Yes. And Milord, last amended applications were filed on Milord. This was
Amendment application filed by the plaintiff.
Yes, yes.
This application under Article
Filed in 2019
of India is at the instance of the first defendant praying for a direction upon the learned civil judge junior division, Jhargram, to sought and proposed to be passed. There is no necessity to direct issuance of any notice. Yes, call the next matter.
Hello, 23. I appear on behalf of the.
Yes.
I appear on behalf of the petitioner plaintiff. Suit for partition. This is an application paying for expeditious disposal of application filed under Order 39 Rule 4 by the defendant and the injunction application itself. My lord, the
you are the plaintiff.
I'm the plaintiff petitioner, my lord. My lord, this is a partition suit between the brothers and sisters, my lord.
This application under Article 227 Yes.
24, I am appearing for the plaintiff petitioner, my lord, for the expeditious disposal of the my lord, partition shoot, my lord. Order 39, Rule 1-2, my lord, is pending. Only ad interim injunction in the nature of status quo was passed back in 2011, my lord. My lord, I am praying for the early disposal of the suit along with the connected applications. No, the suit is pending since 2011, my lord. Before the, my lord, Civil Judge Senior Division, 3rd Court. And my lord, next date is fixed for fixed, my lord, 22nd May 2025. In the meantime, my lord, the plaintiff number 2 have died.
Have
And
the defendant numbers 19, 20, 24, 34 to 37 have filed the written statement?
Yes, my lord.
When did you file the written statement? The date has been fixed on 22nd of May 2025.
Yes,
And they have already filed the written statement.
No, my lord, for filing the written statement.
So, how can a direction for expeditious hearing be passed? I'm not going through the order sheets, mechanically filing these applications under 227 for expeditious hearing. The suit is not ready for hearing. The date has been fixed for filing of the written statement, and you are coming up with a 227 application.
My lord, since the matter is pending since 2008.
Maybe you are responsible for this delay. 2011 suit, you are the plaintiff.
Yes, my lord.
On how many occasions it was adjourned?
It was adjourned for more than.
On your ground,
Not, my lord, due to.
Not on your ground.
Yes, for due to local bar resolution and the defendant also.
Yes. And the steps to be taken by the plaintiff for service upon the defendants, 8th of September 2022, 9th of July, series of dates, you have not taken any steps. Suit ought to have been dismissed on that ground itself.
And the defendant also took adjournment on considerable period.
Both of you are responsible.
Kindly consider that.
None appears for the petitioner at the time of call. No accommodation has been sought for either. Stop in view thereof, CO number such and such stands dismissed for default. Yes, call the next matter.
26. Madam, for the petition.
Yes.
Lord, this is not against the refusal of an application, Lord, under Order 1, Rule 10, filed by the plaintiff.
Order 1, Rule 10 rejected.
Yes. Lord, I am for the plaintiff.
Whom do you want to add?
Lord, I want to add, my lord, the BL and LRO in the suit.
Why?
Because, my lord, what happened?
What is the suit for?
The suit for declaration.
Declaration of your title.
Declaration of my title.
So what the
What
BLR
happened, my lord? I tell you, lordship, what have happened. Lord,
show me your plaint.
Your lordship kindly comes to page 13 onwards.
Yes. Why do you want the BLR to be added as a party?
I
What
tell
the
you, lordship, my lord, what have happened? That admittedly, my lord, by deed of sale, my lord, my predecessor in interest have purchased this property. All along we are in possession. Suddenly, my lord, the defendants, my lord, are claiming in their written statement that there was a certificate proceeding. And by dint of that certificate proceeding, they have got the title of this property. And the certificate proceeding was at the then JL and LRO, my lord, conducted that certificate proceeding.
Can
Now,
you
my lord,
challenge that in a suit?
No. What I, my lord, propose to do, my
Cannot
lord,
challenge that in a suit.
the
BLRO?
concerned BLRO, my lord, is the certificate officer, my lord, as they are alleging.
Yes.
Now, my lord, whether, my lord, this certificate, my lord, is at all genuine or not, my lord, for that reason, my lord, that is
For
to
that, BLRO should not be made a party.
So otherwise, my lord, they are not also producing the certificate.
That
Lord,
is-
your lordship sees they are.
That you have to take other steps. For that, BLRO cannot be made a party.
But my lord, he is the best person to give answer whether it's genuine or not, because they are not producing the original certificate also. They are simply stating that, and on the basis of that, BLRO have changed the record of rights.
Yes. So now you want correction of the record of
No,
rights.
that's my lord a different aspect. That's different aspect.
Not a different aspect. That is the main aspect. 51C2 is a bar.
No.
CPM.
My lord, I am-
Already 27.
27.
Lordship, in this matter, I am on behalf of the petitioner, Lordship.
I am appearing on behalf of the plaintiff opposite.
Yes.
Lordship, kindly give me a liberty to file a supplementary affidavit, Lordship. It is required very much, Lordship.
Why? What for?
Lordship, I have to file a partition deed, Lordship.
Partition deed. What is
Yes,
the
Lord.
impugned order?
Lordship,
Are you ready with the matter?
Uh,
Or you are not ready with the matter?
Lordship,
Say frankly.
it is required, Lordship. The partition deed is highly required to file.
If the order of injunction was allowed in our favor, ad interim order of injunction by the learned trial judge, they went into appeal before the learned additional district judge at Barackpur. Their appeal was rejected, affirming the order of the learned trial. It is an
Ad interim or temporary?
final temporary injunction.
Temporary injunction.
Is an institution running for more than 35 years. The defendants were disturbing the running of the institution. We instituted a suit. Injunction was granted only to
Temporary injunction is otherwise ready for hearing. Temporary injunction application.
the of my law.
You said ad interim.
Temporary.
Temporary injunction.
Temporary. All right.
Lordship, kindly give me a liberty, Lordship. It is highly required, Lordship.
On the prayer of the learned advocate for the petitioner, leave is granted to the petitioner to file a supplementary affidavit. First up, let such supplementary affidavit be
Within
filed
1 week, Lordship.
within a week from date. First up, list this matter in the monthly list of May 2025.
Grateful, Lordship.
Yes, call the CPM matter.
152.
My lord, I am for the petitioner led by Mr. Pathapatim Roy, my lord. My lord, I am for the plaintiffs.
One.
Oh, I am sorry, my lord. This is
Item
Item number 30. You do not have Mr. Mukherjee at 3 p.m. fixed matter.
I am sorry, my lord.
Like this matter, my lord, I am led by Mr. S.N. Mukherjee, Bhogo Ghosh, Probal Mukherjee, and Paniruddha Chatterjee.
What do you want?
I am seeking for not to remand because none of our counsels are there.
Yes, Mr. Mitso, what do you say? Blame was on the court, it is not taken up.
I am here, my lord. I am here, my lord. It was fixed on, my lord, whenever it was fixed. My lord, I was here.
What happened to the, I think, the hearing was fixed before the...
It was extended. It has been fixed on, my lord, 22nd.
22nd of April.
Yes, I had to, my lord, file another application. This is the first one. The second one has been filed because
challenging those extensions.
Extension. Now, my lord, I can show you.
Lordship, do something with regard to this.
My lord, that is for your lordships, my lord. No role to play. Should not happen. Should not happen.
But now there are
It's continuation.
But there are two division benches saying, taking two different views. There are two division benches taking two different views. And the issue was pending before a larger bench. Now, constitution has to be changed.
Oh, अच्छा. Odisha कैसे चला? Now, my lord, I will.
The issue which is coming up because if a matter is pending with regard to these injunction matters, it has to be extended and repeated in one of the matters. If I am not wrong, I think Mr. Mukherjee was also there. Mr. S.N. Mukherjee was also there in that matter. There were 9 civil revision applications. 9 civil revision applications, and one of the matters was assigned.
Oh, I see.
To
The
me.
rest?
To me. No. So initial was assigned to me. Thereafter, but I was not having the regular determination. Then the extensions had to be challenged before the regular determination. Then released and then again assigned 9. When I finally disposed of, there were 9. It was 9 civil revision applications. The cost title was longer than the judgment. And at times it also is difficult because to challenge and
Particularly, my
also
lord,
takes time because if the other side takes an objection with regard to this,
my lord, there is another aspect, my lord. All litigants are, my lord, not solvent enough, my lord, to do it. All litigants. That is one aspect also.
what is to be done with this?
My lord, I can show your lordship, my lord. I can appreciate their difficulty.
None of you are led by many seniors. None of your seniors.
They, my lord, when it was fixed, I think, my lord, it ought to have been pointed out that they will not be there. Be that as it may, my lord, I do not want to take, my lord, raise an
But
issue
it was
on that.
fixed on 28th of March. It was fixed initially on 28th of March. So
now,
today
I will
is not a
kindly give us some time any day, my lord. 22nd, my lord. I know they are seeking not today, my lord. Then kindly fix it on tomorrow, my lord. Hardly anybody would be there. We can do it.
tomorrow. Hardly.
No, if people are not here to. No, you said not today.
Not
No, no.
Tomorrow, what will happen?
not today and tomorrow because they are not there, my lord, this week.
No, my learned friend said not today. That is why I said.
But your next of saying is correct. That tomorrow there may not be many one. So next week when?
Monday, my lord, kindly.
Extend
22nd, my lord. Fixed on 22nd.
Fixed on 22nd. Monday may not be possible. Either tomorrow or on Tuesday.
My lord, I will show your lordship, my lord, that I will tell your lordships very briefly. Now, my lord, they have, my lord, in this suit, my lord, they challenged.
I appreciate on the merits. I can fix it on Tuesday or Wednesday.
Tuesday
key paper. Tuesday.
Tuesday is 22nd, my lord.
কি আছে আমাদের monthly list Tuesday টা Wednesday I'm fixing
the difficulty would be, my lord, 22nd.
Another
I cannot file it by 20. I will not get the certified copy.
It will be an automatic extension. You come thereafter, I will consider.
Then I shall give the
But
number.
if you want some more time, I can give that also.
No, my lord, there is some urgency, my lord. Unnecessarily, my lord, I would say, as an, my lord, not as a counsel appearing on behalf of our party, their allegation was that, my lord, matches were fixed on consecutive days in respect of 2 tournaments. My lord, it was IFA had readjusted so that it was not, my lord, on consecutive days. Still, they did not participate. And then they challenged. After the, my lord, date was over, then they challenged. So very short point is involved.
It's only one thing. Nowadays, the orders of the trial courts are available in the server on that date itself. Or the trial court or the first appellate court, because this is the first appellate court, I think. So those are available in the server. This will be an extension, as you are saying. If it is an extension, those orders are available in the server.
Copy দিয়ে করে দাও।
সার্ভার কপি দিয়ে করলে আমাদের লিভ নিতে হবে
হ্যাঁ তো লিভ নিয়ে করবে, এখানেই তো লিভ হবে।
I can fix it not on Wednesday because you are saying that the date is fixed on 22nd,
which is Tuesday.
So I can fix on next Thursday or Friday. So you'll be getting 1 or 2 days more.
Thursday, my lord.
Thursday, all your counsels will be available.
3 p.m.
3 p.m. ছিল নাকি?
Oh, 2 p.m. It can be, but
so the difficulty is that
I know your lordship.
2 weeks, nothing happened. So far as this court, I am not saying no.
আমি শুনিনি 2 p.m. করছিলেন।
Mr. Mitchell Arnett.
Another extension.
Mr. Mitchell Arnett, senior advocate, appearing for the petitioner, submits that challenging the order extending the interim order has been challenged, being CO 1150 of 2025. The list CO 1150 of 2025, along with this matter on next Thursday date দিয়ে দিন। ঠিক আছে?
এটা 50 না 58 আমি ভুল লিখেছে বোধহয়।
50 filing number.
58 হবে।
58. But here it has been mentioned.
No, filing number and registration number মানে
58, 1158 করে। An accommodation has been paid for on the ground of the learned senior counsels representing the opposite party number 1. Who is the other opposite party? There are how many opposite parties?
They are the other defendants. They are the plaintiffs. They are the other defendants.
Who are representing them?
They are the plaintiffs.
opposite parties.
No, the last order says opposite party number 1.
Yes, opposite party number 1 is the plaintiff. The other opposite parties are the co-defendants.
Anyone is representing them here? So Mitra, I do not know what will happen if the others opposite parties come and say we were not heard.
কারা কারা ছিল? সবাই? Oh, they are the office bearers of IFA.
They are the
সার্ভিস করে দাও দিয়ে এসো।
I'm not passing any formal directions.
Very good. সার্ভিস করে affidavit সার্ভিস ফাইল করো।
Opposite party number 1. Stop. List.
My lord, I am for the petitioner.
Yes.
My lord, this is the application for expeditious, my lord, disposal of title suit, my lord, for recovery of first possession. The suit is of 2018. Initially, my lord, defendant appeared but didn't file their written statement. Matter was fixed ex parte. Thereafter, they filed, my lord, vacating application that was allowed, my lord, and subsequently, my lord, the plaintiff filed one application, my lord, under Order 26, Rule 9 for local investigation, my lord. That was filed on 8 February 2023. They took time and ultimately, my lord, ex parte, the matter was fixed ex parte, my lord. That was vacated upon payment of cost, my lord. And they, what my instruction is, now they have, my lord, deposited that cost of 200, my lord. That now this application is, my lord, ready for hearing, my lord.
Which application is
my
ready
lord? On behalf of plaintiff, my lord, one application under Order 26, Rule 9 was filed, my lord, on 8 February 2023, my lord. Time and again.
5th of December 2024.
My lord, thereafter,
the petition.
Yes, my lord. Thereafter, my lord, till date, that has not been hard out, my lord. However, my lord,
next date fixed?
My lord, next date 7th May 2025, my lord. My instruction is this, my lord. 7th May 2025. That only. Otherwise, my lord, written statement on record, my lord. My only application, this interlocutory application is pending, my lord.
This application under Article 227 of the Constitution of India is at the instance of the plaintiff.
29, your lordship, I'll pray for release. Mr. Shona Bhattacharya is appearing on the petition.
Since I'm not inclined to take up this matter on personal ground, this matter stands released from the list of this bench. Let the records of this case be placed.
30.
Yes, Mr. Mukherjee.
Madam, I am for the defendant number, and I am for the plaintiff number 1 to 4. Appellant
defendant.
Plaintiff number 1 to 4. Appellant petitioner. Number
Injunction.
Not injunction. I filed a suit for declaration injunction that a deed of gift or the sale deed both are void because the father of the deed of gift, deed of gift and the sale deed both are void because the father of the defendant number 1 has no right or capacity to transfer the property. An injunction not to disturb by possession. Now, a suit was heard on several occasions. Ultimately, when a trial court found that yes, the father of the defendant number 1 has no right, therefore, declared that the deed of sale is void and deed of both are void. Now, during pendency of the suit, on the basis of that deed of gift, a part of the suit property has been recorded in the name of the defendant number 1.
In the record of rights.
In the record of rights. As I have not paid for recovery of possession, my suit has been dismissed. I preferred an appeal. Before the appeal court, I filed an application for amendment of the plaint. That has been turned down by the order.
Rightly.
Now, may I just try?
Rightly done. Where is the latest Supreme Court decision?
That I've now, kindly see once. But
show me the latest Supreme Court decision on that.
Kindly consider other way. I filed.
Is it against the settled proposition of law, or it's in tune with the second? I'm asking you as an officer of the court.
But if your lordship consider in other way, but there are several judgments your lordship is considering.
The latest. I'm talking about the latest.
But if I say that while considering the proposed amendment, court ought not have gone to the merits of the case. Now, at the court on which ground has been rejected, I will show from the face on record that is not right.
Appellate stage, Mr. Mukherjee.
I know, but kindly visualize when admittedly court found that the father of the defendant number 1 has no right over the property and
But you are not in possession, Mr. Mukherjee.
I am in possession only record of rights. Now, kindly see once. Because
you are not in record of rights, may say something. Were you in physical possession?
Absolutely. From the beginning, it is my case.
Then there is no necessity to pray for recovery of possession.
Now, kindly see once why
there is no necessity. I'm on that.
But on the basis.
Why have you prayed for amendment, Mr. Mukherjee? Then, if you are in possession, you have to proceed with your prayer for
averment. On the basis of my averment, when they have shown kindly see once 2 pages.
Show me your application for amendment.
Yes. But kindly straightway come to my application at page 62.
Yes.
नांगूर वाला फैन रोजिया से आज की पुलिस ने But when admittedly, the father of the defendant number 1 has no right over the property, and the defendant choose not to prefer any appeal. Finally,
Mr. Mukherjee, prayer BB, which you sought to incorporate, is not maintainable. Civil court cannot grant a decree on that.
No, that I am not pressing. I know that. I know
you
that.
know everything, Mr. Mukherjee.
But this is prayer. If you lordship considers page 64, BB, I can't file the suit.
BB, you are not pressing.
BB, I am not pressing.
I'm recording that. BB, yes, not pressing. Then BBB.
BBB, I have to.
BBB, you have to. So, how have you valued the suit, Mr. Mukherjee?
But suit valued on the basis of the
recovery of possession, it has to be on the market value.
If it is allowed, then I have to.
That is return. Valuation, you have to make that. Amendment. Not another application for amendment.
But,
then the court, it will house the jurisdiction of the court after having suffered
No,
a
my lord,
decree.
if your lordship kindly consider once, my lord,
What is the
schedule
market value of the property?
Roman
Mr.
2, schedule Roman 2, I have stated regarding valuation, I have stated.
What?
Kindly. In paragraph 10 of the amendment plain filed on 12/9/19, after the words rupees 100 for declaration and before the word rupees 100 for injunction, the punctuation and thereafter the word 5,000 for recovery of possession may be
5,000 market value. Where is the property?
How-
Deed, give me the deed value,
এটা আছে। আর করিস না।
market value of the property, when it was registered.
My if the gift deed says, my lord, the deed, my lord, no gift deed says it is void. Kindly see once the observation of my lord, the father, one line, my lord. Kindly see once.
Recovery, Mr. Mukherjee, there are two things. If you pray for cancellation, it has to be as per the market value. You may say, I've prayed for declaration, it's void.
Cancellation
and
already done.
it's not by an executant to a deed. Cancellation need not be paid, that is one thing. But recovery of possession has to be on the market value.
Absolutely, I have to.
So what is the market value of the deed?
But your lordship is of the view opinion, my lord, if it exceeds the jurisdiction of the trial.
Yes, it will exceed the jurisdiction.
Appeal court, my lord, possibly not.
No, the trial court. It has to be remanded then.
But deeds copy I don't have right now, my lord. And if your lordship kindly see once, my lord, the trial court finding, kindly see once. But the entire judgment is, my lord, the trial court, my lord, ultimately.
Trial court or the appeal court?
Trial court.
Why trial court?
Because trial court, man, ultimately dismiss the suit only on that ground. But kindly see the finding once.
No. So you are now trying to take me to the order of the trial court. On what ground it was rejected? Show me your plaint once.
Yes.
Show me your plaint once.
Kindly turn to, my lord, page 15.
1-5.
Starts from page 14 and the averment your lordship will find. আমরা রবিরামটাকে
So in the suit, your stand was that you are in possession.
But kindly see page 24.
24, yes.
আমার নোটটা কোথায়? হ্যাঁ, নোট। But your lordship will find from 5 line from bottom, my lord. The learned court within the statutory period of limitation from the date of knowledge of the said deed of sale in question for declaration and legal status as paid for which the plaintiff is legally entered. Be it stated further that R.S. Arovar said Robiram Khan fraudulently and collusively entered and or recorded his name with Kishori Khan in respect of the A scheduled property, but such record has no legal value in the eye of law on account of basic foundation of for such recording, which is simply illegal and erroneous recording and not binding upon the body else. That apart taking advantage of the said registered deed of sale in question, dated 24, the defendant number 1 has been claiming his alleged ownership. He is required to be restrained by an order of injunction from claiming the alleged right of possessorship in respect of plot number 449 and in respect of any of the present suit plus any manner. Then, my lord, your lordship, kindly see, my lord.
Where is your averment with regard to possession?
I'm a kindly, my lord.
Thank you.
But a part of the portion is in their position because a entire plot.
Show me your averment with regard to possession.
But if you let you consider 3A, page 80. Kalipada Khan had two sons.
Paragraph 3A.
3A.
Yes. This was also by way of an amendment.
This was also by amendment. Because this is third time remand, my lord. Initially, suit was dismissed. then appeal file. Appeal got remanded.
Yes. Paragraph 3A. What have you said with regard to possession?
Yes, my lord. But
Show me that portion only.
Kalipada Khan and two sons, Toshibhushan and Shuash, the ancestral properties inherited by the said two brothers through their father Kalipada Khan had been duly recorded in CS ROR against CS Khotia number 188, consisting several dag measuring 1.75 decimals, whereas CS ROR in respect of suit dags, including very many other properties, were recorded in the CS ROR against CS Khotia number 49 in the name of the original Jamindars who settled the suit dag as aforesaid. It is necessary to mention that it has already been stated that Gangadhar Khan, while exercising ownership jointly with the father of the plaintiff, sold away a portion of the suit dag 450, which has duly been reflected in the incident settlement as stated above. And it is crystal clear that by virtue of such settlement of the suit property by the Aden Jomidars in favor of the father of the plaintiff and Gangadhar Khan, the son of Subhas Khan, and as such,
The possession, where have you stated? Nothing has been stated.
CS record of rights, our name, my lady. Kindly see the next line.
Yes, record of rights you have stated, but nothing, any positive averment with regard to possession.
But if you are, I am residing there. If you are to see, they are.
Show me your averment with regard to that you are residing. Your possession, I want to see your averment with regard to possession in the plaint.
But may I just say one thing? But if I have not been in possession, they filed this defend number 1 filed.
Not if, but.
But
Where is your averment with regard to possession? I am only asking you, show me your averment with regard to possession. Not if and but.
But in paragraph 4, my lord, they have already filed a suit for partition on the basis of that, my lord, registered deed of gift.
So there is no positive averment with regard to possession in the plaint.
But kindly give me one, but I have not specifically.
All right. So now you are trying to show the judgment of the trial court. Yes. Which portion?
Kindly give me 1 second, my lord. Now, my lord, trial court judgment, if your lordship see once. But why I am showing page 53? Kindly see once page 53 first of the trial court judgment.
Page 53.
53. Exhibit B is the certified copy of the application in connection with MP case number 1115 of 2009.
Exhibit B, yes.
Under section 144 CRPC by the plaintiff against defendant number 1. In that case, the plaintiff admitted the defendant number 1 is a joint owner and occupier of the Act number 449. This court is remindful of the settled principle that suit and case may come and go, but admission remains. But the said principle is not well applicable in this case. A person can not get title over a property or be deprived of it merely because of any admission. It is for this court to decide the title of the party of this suit, but such admission can be useful in other respects. Accordingly, Exhibit B has no significance in deciding the title of the parties. Now, kindly straightway come to my lord. But kindly see page 55.
Page
55. The finding.
Yes.
It is already admitted, my last paragraph.
Yes,
It is already admitted position that the defendant number 1 failed to file any document showing that Shashi Bhushan Khan and Subhas Chandra Khan were the original owners of the suit property. On the other hand, plaintiff filed some documents which corroborate his claim. The plaintiff filed deed of Qobuliyat which has been marked Exhibit 1. This court is mindful of the legal position that both the deed of Qobuliyat as well as Patta must be produced to prove whole transaction. Mere filing of any document is not sufficient to come to any conclusion, but it must be kept in mind that the plaintiff is only obliged to show preponderance of the probability, and there is no question of asking the plaintiff case beyond reasonable doubt. The said deed of Qobuliyat executed on 23/7/48. The plaintiff filed one sale deed dated 28/2/47, and according to the sale deed, the father Kishori Mohan Khan, that is Shashi Bhushan Khan, was not alive in the year 1947. Therefore, there is no question Shashi Bhushan Khan was alive when the Qobuliyat was given in the year 1948. Exhibit 5 is another document in between the Kishore Khan and Harendra Krishna Khan, whereby both the parties, that the Gangadhar is the owner of the half of the suit plot 450 and Kishore Khan is half of the owner of the Dag. The said document acknowledged the corroborated plaintiff case in the suit Dag number 450 was given to Kishore Khan and Gangadhar Khan. Exhibit 2 is a purchase deed Harendra, whereby he has purchased the share of Gangadhar in suit that 450. Now, both documents support the ascertain the plaintiff Dag number 450 belongs to Gangadhar Khan and Kishore Khan. From Exhibit 7, it appears that the CSROR, the suit Dags are recorded in the name of Shashibhushan Khan and Subhash Chandra Khan. On the RSROR, Exhibit 8, it appears that the suit Dags are recorded in the name of Kishore Khan and Gangadhar Khan. My predecessor name are recorded, it has been stated. And reference recording Kobulias was duly noted in the said document. The defendant number 1 also admitted title of the legal heirs of Kishori Khan at the time of cross-examination. As I have already stated that the deed of Kobulias cannot stand on its own, but when other materials categorically support the plaintiff's case, in that case, this court cannot bluntly ignore such document. This is a suit for declaration in between the plaintiff and defendant number 1, and the judgment passed in this case will be judgment in personam. Only the parties of the suit will be bound by the judgment or decree of this court. Considering the preponderance of probability, there is enough evidence produced before this court that supports ascertain of the plaintiff. Exhibit 6875321 supports the case of the plaintiff. Taking into consideration the whole evidence produced on behalf of the plaintiff, this court is of the view that the plaintiff managed to prove the suit Dag belongs to Gangadhar and Kishore Khan. The suit Dag never belonged to Shashibhushan and Subhash Chandra Khan, and therefore Robiram alias Obiram cannot transfer the suit property in favor of the defendant number 1. Our predecessor name was recorded, my father's name was recorded. After that, my lord, my name was recorded when the suit was filed. Subsequently, during pendency of the suit, my lord, he managed to record a part of the portion. Therefore, up to this portion,
but you are in possession.
My lord, recorder rights presumption of possession.
You have to rebut that.
Now what happened?
Have you rebutted that presumption?
No steps has been taken, but in the plaint.
Rebuttal of presumption.
Yes, in the plaint.
In the evidence, did you rebut that presumption in the
and
evidence?
The plaint.
So, Mr. Mukherjee, there are two things. One is, factually, if you are in possession, then mere wrong recording in the record of rights cannot take away your possession. Then you need not pray for recovery of possession. So, if you are praying for recovery of possession, this shows that you are not in physical possession of the property.
Now, if your lordship see once in the but if you let's see that the plot number 450 is a huge plot. But initially our predecessor name was recorded. Now, my lord, taking the advantage of the suit, my lord, they have not only recorded, they have taken a part of the portion. Now, my lord, up to this.
So they are in possession of a part of the property.
Yes, absolutely. Now, my lord, kindly see.
Then when they took possession of the part of the property, Mr. Mukherjee?
My lord,
when they took possession of.
But that has not been stated, my lord. I
have to state that.
Now
overcome the point of limitation, Mr. Mukherjee.
Now, my lord, may I just quote your lordship? Now, my lord, ultimately, my trial court found after 3 times remand that the deed of gift which has been executed by the predecessor of the defendant number 1 is void, because the father of the defendant has no right over the property.
No difficulty on that.
Now, why?
Now, whether you are entitled to relief in view of proviso to section 34. That is the.
Absolutely. If I have not claimed for subsequently, but kindly see page 58.
Why comes the latest decision of the Supreme Court?
That is against. Kindly see page 58, my lord. Once more. Kindly see page 58.
Yes.
For a little place where the defendant has no right over the property. But kindly see page 58. Why I lost the suit, my lord?
For that, Mr. Mukherjee, you obtained an order of injunction in the suit.
No, my lord. Ultimately. Initially, my lord, right now I can't.
Yeah, you have. Because by saying that you are in possession,
no,
injunction, now up to the last stage, injunction, then it was dismissed.
Now why? But that injunction, I have to take, whether the injunction was subsisting or not. And another thing, why I lost my kindly see page 58. The
58, yes.
Defendant number 1 filed LROR, which has been marked Exhibit A. Exhibit A shows that defendant number 1 is in possession of property. It is needless to mention here the record of right is not a document of title, but rather It is a document of possession.
Page 58, which portion you are
The
placing?
last paragraph.
Last paragraph. Yes, yes. Yes, yes.
This is the only paragraph for which, my lord, my suit has been, my lord, has been dismissed, my lord. And ultimately.
No, next paragraph. Page
Yes.
59.
Page 50, my lord.
Entire page 59.
60, my
Entire
lord.
page 60.
60, my lord.
Entire
60.
page 60.
The plaintiff is.
Your evidence have been entirely discussed, Mr. Mukherjee, there.
No, my lord, if your lordship consider, my lord, that has not. My lord, may I just read for your lordship, my lord?
Have
That has
been
not.
discussed. Your evidence.
May
What
I-
was your statement in the MP case? Page 60, first paragraph.
That's why I show you lordship page 53. MP case, my lord, when they have filed a suit for partition on the basis of that deed of gift, they are, my lord, initially I admit that they have a right over the property. Now they are saying, once I admit, therefore I cannot maintain this suit. Now, my lord, kindly see the order of the learned lower appellate court rejecting my amendment application. Kindly see once.
Yes.
But up to, my lord, first 2-3 pages, my lord, our case has been discussed.
And the decisions have been set out.
No, but this is my judgment, my lord, only, my lord, quoted. If your lordship
Yes, yes, only quoted. Then I have perused page 3.
I have perused the decision filed by both the sides and after also perused the document filed by the party. I have also perused the impugned judgment passed by the trial court. Trial court has given specific observation. The plaintiff was given liberty to amend the plaint. It is important to mention here that the plaintiff amended his plaint during the appeal proceeding, but no prayer for.
In the appeal also you have amended.
No,
once.
Absolutely that I have stated. That is wrong, my lord. This is first time amendment has been filed. The plaintiff did not amend the plaint even when liberty was given by him by the first appellate court. But this is the judgment of.
That was at the time of remand. Yes.
This is the third time appeal, my lord. In the said decision, now, my lord, another judgment has been discussed. Now, in the light of the aforesaid judgment and in the facts and circumstances of the case, it is very much evident that the proposed amendment which the appellant wants to introduce is not at all a new fact, and despite having knowledge of the such fact, appellant did not take fresh steps for insertion of the same by amendment during the trial before the trial court, even after remand of the previous appeal and subsequent opportunity allowed by the trial court. It is also evident that if such amendment is allowed, it will take away the important right which has been accrued in favor of the respondent by virtue of the admission by the appellant regarding the joint ownership over the suit plot. This is wrong. Joint ownership, my lord, the court is saying, kindly see page 53. The trial court has specifically stated, as I have admitted joint ownership in other partition suit, therefore this I can't claim. But kindly see page 53 once. Regarding the joint ownership over the suit plot by the appellant and the respondent and the right accrued by the preliminary degree passed in the partition suit. But kindly see once, my lord, that appeal is pending.
In the partition suit.
Partition suit. But kindly see page 53 once.
56.
53.
3. Yes.
The trial court specifically found mere admission will not do. But in spite of the said, my lord, appeal court said the trial court found that it is an admitted fact. But kindly see, this is contrary, my lord. Once kindly see, my lord, page 53.
That was the trial court's observation. Appeal court.
No, appeal court says.
But the hierarchy of appeals, Mr.
Absolutely. Absolutely. What is fallen from your. But kindly consider, this court is remindful of the subtle principle that a suit and the case may come and go, but the admission remains. But the said principle is not at all applicable in this case. A person cannot get the title over property or by deprive of it merely based on any admission. And the appeal court is totally contrary. Appeal court did not at all consider against the preliminary degree appeal is still pending. Because in the appeal court, we have taken the specific plea that the father of the defendant number 1 has no right over the property. How can he transfer? That has not been considered. And your lordship knows better than us that this is the judgment while considering the amendment court should not gone into the merits of the case.
That is the latest decision of the Supreme Court. Please to see that latest decision. You have got that? Because I'm not aware of the latest view. You are aware of the latest view of the Supreme Court. Please give me that judgment.
But that is in respect of the.
Please give me that judgment. I'm not aware of that decision. Please give me that judgment.
That judgment I have not.
No, you have brought that.
No, that I have not. Because
bring that judgment on the next day. Give me that judgment, Mr. Mukherjee. I'm not aware of that judgment. Give me the latest view.
But kindly visualize my predicament of my. This is interest. This is other. It's not gone into the merits of the case written there because that
The other judgment.
other judgment, my lord, now the Supreme Court is of the opinion that I have to make a joint, my lord, relief on whatever. If I have not paid for, then subsequently I know that. But there are contract.
I do not know. I want that judgment.
We are learning from your lordship,
Give
my
me
lord.
the citation, Mr. Mukherjee.
But
Give me the citation.
may I hard copy and come?
No, you will serve. I will definitely give you, ask you to serve.
But third
Give
time
me that judgment.
I will give you that.
Give me that.
No, today I am not.
No, you have
No,
got that.
I don't.
Give me those bunch, I will find it out from you.
No, today I don't. I know that is against me.
No.
I
Mr. Mukherjee, you should have placed the judgment which is against you.
not with me, my lord. Truly speaking, not with me.
Ashwin, after some argument, Mr. Mukherjee Lahaned, advocate for the petitioner, placed for an accommodation to place certain decisions.
So against it,
To place the recent decision of the
judgment, not recent decision.
To place certain decisions in support of his case. To stop.
But third time, my lord, remand.
Mr. Mukherjee, what can be done? Now is the latest view.
But the appeal court judgment, kindly visualize whether your lordship is considering the appeal court.
Not on that, Mr. Mukherjee, the fact remains in the evidence you have admitted. If in the evidence you have admitted they are in possession, you ought to have, after remand, you ought to have paid for.
That I will see, my lord, regarding the evidence, my lord. Yes.
Because after that, you ought to have paid for that. Because that is your evidence. And you have to say when, maybe Mr. Mukherjee, initially when you filed the suit, you were in possession. Those are the line of decisions where subsequently you can, yes, after disposition, you can amend your plaint by converting a suit for declaration and injunction into a suit for recovery of possession. In that, you have to say when you have been dispossessed, and after that, during the pendency of the suit, for bringing on record the subsequent events, amendment is permissible. But if your admission is there and you have not taken steps for a pretty long time, whether after lapse of certain time, you will be allowed to amend your plaint to pray for recovery, that is an issue. Whether that relief is time barred or not, that is to be considered. When was your admission? When they took possession?
I will consider that.
You know? Stop. List this matter. When? Wednesday?
After 2 weeks.
After?
After that matter.
I do not know after that or before that. Yes, next.
31. Lordship, this is my application for expeditious disposal, your lordship.
Of what?
Of your lordship, all the interlocutory applications, your lordship.
What are the interlocutory applications?
Lordship, the suit was filed on 22nd November 2018. On that very day, an interim order was obtained. Your lordship kindly comes to the interim order once. Kindly see how the interim order was extended.
What are the interlocutory applications which are pending?
Lordship, I have filed an amendment application. I have filed an application under section 39, rule 4. They have filed an amendment application.
They have filed an amendment. Who are you in the suit?
I am, your lordship, I am the defendant number 2. 2.
So you have filed order 39 rule 4 filed by whom?
I have filed, your lordship. Defendant number 2.
This application under Article 227 of the Constitution of India is at the instance of the second defendant, praying for a direction upon the Learned Civil Judge Junior Division First Court Barakpur to dispose of the interlocutory applications filed in connection with title suit number 286 of 2018 expeditiously. First of the learned advocate appearing for the petitioner submits that the application for amendment of plaint filed by the opposite party number 1 herein as is pending. She further submits that the application for injunction filed by the opposite party number 1 and the application under Order 39 Rule 4 of the Code of Civil Procedure filed by the petitioner herein are also pending. She further submits that the aforesaid applications
Lordship,
for amendment.
Lordship, I have also filed an amendment application. That is also pending, Your Lordship.
Further, what is the next date fixed for this
Lordship,
application?
15th July 2025, Your Lordship. I'm praying that if this date can also be shifted back, Your Lordship.
15th of July 2025.
Yes, Your Lordship.
So which order records your application under Order 6 Rule 17?
Your Lordship, kindly comes to the order dated 25th January 2023, Your Lordship.
25th
Order
of
number
January 2023.
order number 16, Your Lordship.
She further submits that the petitioner hearing also filed an application under Order 6 Rule 17 of the Code of Civil Procedure on 25th of January 2023 for amendment of the written.
It has been filed, Your Lordship, on 27th of September 2022. The order records it, Your Lordship. Order 6, Rule 17 and Order 39, Rule 4.
It appears from the case record that the defendant files a put-up petition on 27th of
and
September.
with that petition, these two applications were filed.
अच्छा, की बोलना? Rule 17 of the Code of Civil Procedure for amendment of the written statement on 27th of September 2022. She submits that the hearing of the said applications have been fixed on 15th of July 2025. She also submits that the applications are otherwise ready for hearing. In view of the order sought and proposed to be passed, there is no necessity to direct issuance of any notice upon the opposite parties. However, the learned advocate on record of the petitioner shall be obliged to forward a copy of this application along with this order upon the opposite parties or upon the learned advocates representing the opposite parties before the learned trial judge. First up, from the order sheets appended to this application, this court finds that March 4th, 2025 was fixed for hearing of the application. It's only the hearing of the application for injunction. What is the next date fixed? Which order records?
Item 32, Mr. Chitopriya Ghosh is appearing for the petitioner. He is not come to court due to personal difficulty. I am praying for not today, my lord.
An accommodation has been paid for on the ground.
My lord, I am paying for not today. Mr. AOR could not come today due to illness.
On the prayer of the learned advocate.
Petitioner
Yes,
husband
Mr. Ghosh.
and the husband or attempted husband. Husband filed a suit for.
Please use the microphone.
Husband filed a suit for dissolution of marriage. 2013. My lord, section 24, it was filed. My lord, I have annexed the entire order sheets. Section 24. My lord, kindly see the order sheets.
Yes. What is the order under challenge?
My lord, I being the primary teacher, I am getting only 31,000 per month.
You are getting
31,000. Learned trial court awarded maintenance of 8,000 per month. And backlog areas right from date of the filing of the applications. No, my lord, this is exception. My lord, kindly consider this. Why? I would not have come. My lord, miscellaneous case, it was filed on. Miscellaneous case, it was filed. My lord, page 32, my lord. 28 June 2018.
Yes.
Up to 2023, the summons of miscellaneous case was not served upon the husband. Well, kindly see the entire order says I have annexed. It is not that I am contesting the section 20 proceedings since 2018. Simply after filing of the application, SR and AD. No requisites, nothing, no summons, no notice upon the husband. Now, husband appeared and filed reaching objections. But, well, kindly see this ABJB in chief.
When you appeared?
Well, kindly see these orders.
When you appeared
After getting page 45, order number 75. On the basis of postal tag report, matter was fixed for expert hearing.
Page
45, order number 75. That is
Order number
17th August
75.
2020, order number 45. 2018 file. Now postal tag report considered on 17th August 2022. Next date, 31st October expert hearing.
31st October for expert hearing.
Expert hearing. No written objection was filed. No opportunity was given to the husband to file written objections. Thereafter, learned trial court insisted the learned advocate of the husband to cross-examine the preserved one. No time will be granted. Immediately after facing of the judge of expert hearing. It is not that the husband filed written objection. No opportunity was given to him. Well, kindly see the entire orders. I have annexed it. Cross-examined. It was done on 22nd December 2022. Like question, I am asking myself, should I not be allowed to file written objection against the section 20 applications? Learned trial court insisted now petitioner's wife must be cross-examined today. He cross-examined. After consideration, 22nd January for further evidence. Since 2018, my lord.
What happened to your application at page 71?
Page?
Page 71 application for recalling. What happened to that?
Nothing.
Recalling
That
the order dated 27th of April 2023.
yes. That was not considered, my lord. That was not considered immediately fixed for order, fixed for passing
What
of
do
the
you mean
order.
by that? That was not considered. Has to be considered. Where is that order? 27th of April 2023. Where is that order?
That order has not been annexed, my lord.
Yes, that order, all the orders have been annexed. That order is not here. And what happened to this application? What order was passed on page 71 petition?
My lord, I came to learn the non-moved petition rejected.
Then,
but on the day of the resolution of the bar,
that is up to you. There was a resolution of the bar. So you
well,
filed an application
I have
that
asked
was
my client.
rejected, not challenged from 2023. You have accepted that.
No, no.
Now, how can you challenge
that
this
day,
now?
On that day,
All the orders have been annexed, accepting that
Lord,
order.
I shall annexed it by file a separate review. But I came to learn. I put a questions to my client that what is the on the day of resolution, nothing, no adverse order resolution, but the just take up the matter and reject it.
So that order you have not challenged. You have not challenged that attained finality. So that your right to file written objection goes.
No, my lord, immediately after facing a date of expiry hearing.
You have a decision in your support that if for a long time no summons was served of this case, and this principle of starting from the date of application, you have not got that judge. You have not got that judge. You have not searched what can be done.
Look,
Then let me affirm this order.
I am leaving it to your lordship, my lord.
No, don't
I have one judgment, my
Don't
lord.
leave to the
I have
court.
that is domain of the court. That is the discretion domain of the court from the because the impugn order, learned trial court directed the husband to pay from the date of filing of the application.
After all,
That should not have been
after all,
done.
you will be paying to your wife, not to a stranger.
But the 31,000, if it is, my lord, so it's 17,500 and 8,500. I am only getting 5,500 per month. Well, kindly see this situation. Record, kindly see the order impugned.
1/3 is also the rule.
31
1/3 to 1/5. 1/3 of 31 comes to 10,000. More than 10,000, 8,000 has been directed.
8,000. And from the date of filing of the application, it comes to 25,500. Only 5,000. It is impossible.
With that, I can expedite the suit.
Well, kindly interpret the order. It is impossible to pay the backlog from the date of the application.
From which date you are willing to pay?
Well, it should not be from the date of the order.
Not from the date of the order.
Perhaps 23, when I appeared and cross-examined the PW1, when I was given the opportunity to cross-examine the PW1 wife, from the
When
date
did
of
you appear? When did you appear?
well, from the order sheets.
Yes, I am asking you, what is the date when you appeared in the miss case?
22nd, well, I'm telling the date. I'm telling you.
So you can pay from that date also.
Yeah.
You appeared. Even if the earlier period is, for the present you pay for that. I will decide on the balance after they come.
70,000 too much. Very impossible to pay. 31,000. Well, kindly appreciate the sufferings of the husband. 5,000 only in my hand.
Is nothing.
5,000 in my hand. 26,000 going to the wife. I am getting only 5,000.
26,000.
17,500 from the date of filing of the application.
That is the installment with regard to the arrears.
But it has now become very difficult to pay.
I can reduce the number of installments. I can expedite the suit. That I think will be beneficial. You have to pay a lesser amount.
I cross-examine the PW1.
Pay the entire amount within 1 or 2 months. I will direct the suit to be disposed of within 6 months.
From the right from 22. 22, I appeared and cross-examined PW1 wife.
You appeared in 2022.
22. Well, look, kindly see order number 17.
All right. So from 2022, you
order.
I will direct you to serve with regard to the arrears. Here I cannot modify from here.
Well, I'm passing with this by very difficulty.
What are you doing?
Private teacher.
Fabulous income.
31,000.
Fabulous income. Yes, yes. In which subject? In which class? Of which class?
But I cannot say right now.
You also maintain a list of students, Mr. Ghosh?
No.
Have to.
No, nothing. Nothing. Actually it became disbalanced
This
after.
shows that you are not disclosing the proper income.
No.
Otherwise, you ought to have maintained.
ABJB assets.
You ought to have maintained a register, the name of the students,
ABJB
their
assets.
particulars.
ABJB assets. I have
This
disclosed.
payment in cash or by bank? Through bank.
ABJB assets.
Everything in cash, Mr. Ghosh.
No, nothing. Nothing. He's not. He's not a private teacher.
No payment through bank account. Why?
Bank account I have produced before the landed court below.
No. Bank account you have produced, but you receive this
And I
tuition
can
fees by
produce
cash.
it right now.
What you will do with bank? Everything is siphoned off. Cash here, cash there.
I have also managed the bank account also.
Yes. Bank account, there will be nothing. The bank account which you will disclose, there will be nothing.
There is no other bank account except one.
How are you maintaining yourself, Mr. Ghosh?
Now, since 3 months, I am facing serious problem.
Prior to 3 months?
31,000.
31,000.
Sufficient.
For
Because
one
we
man.
have no child.
For one man. So that has to be applied for the wife also. It requires 31,000 for the expenses of one person. That is according to you.
No, I have to maintain my elder sister.
So 2 persons.
2
So
persons. And
15,000.
the maid servant is also getting 6,000 per month. 8,000. Maid servant. Well, I have
So
honesty.
you also maintain a maid servant also.
Yes, because who will go? Hello.
That is why.
Who will serve the food? Who will cook?
Yes. So you can pay 6,000 to the maid servant, not 8,000 to the wife.
No, I have honesty. Who will cook on morning and evening?
Yes. That
Because
is
she
why
has left.
6,000
She
you
has
can
left
bear,
the.
but not 8,000 for the wife. Mr. Ghosh.
I am limited to very difficult situation. Very difficult situation.
Lordship, I am appeal for the petition in this matter.
Yes. If the 4 p.m. matters are exhausted, I can again come back. That is up to you. Yes, yes. Yes.
Actually traveling outside the country.
Outside the
Country.
let him enjoy the vacation. An accommodation. Yes, next.
141.
4 p.m. is being called on. Item number 140 has been adjourned. Yes.
141, my lord, I beg to appeal.
Yes. An accommodation has been paid for on the ground of the learned senior advocate for the yes. Yes, who is for the petitioner? Yes, who is for the petitioner?
On behalf of the petitioner, I'm paying
Yes,
for
yes, madam,
short
please
Passover.
proceed.
Lordship, I'm paying for short Passover.
What short Passover? Kindly see at the clock. Start. Passover on whose ground?
Engaging the Siddhartha Banerjee senior.
You will come and join. Please proceed. Please start. Yes, what is this matter?
I have no brief with me.
Please take this brief. Yes.
Lordship, I have no instruction from my senior.
Yes. Take the brief. Yes, sir, you start. Yes.
Filed by the petition and hearing order passed by the Parliament. Basically, it is only one issue whether after passing the order,
After passing
final
under section
14 of certificate,
under section 14 of surface, yes.
estimate the bigger from or he can pass any order in continuation of this order or taking the physical version of
Where is the order impugned? Show me the order impugned.
at the beginning of the volume number 1.
At the beginning of volume number 1, yes. Yes. The order of appeal is under challenge. Yes, Mr. Banerjee, you have come. Yes.
I have come. My brief is yet
All right.
to come. Let me
So let him continue. Yes, yes.
for some time.
Yes.
My lord, passed by the Parliament. The subject matter of this case, my lord, after passing the order by the learned district magistrate, we came to know that the police station of the scheduled property was wrongly typed as T.
You are the borrower.
No, I am the bank.
You are the bank.
I am the bank. He is the
Yes. He is the borrower.
Yes.
Now, what happened? Section 14, where is the order passed under section 14?
Please come to running page.
Page 51, yes. This is the possession notice. Where is the order passed under section 14?
That's section. Order. Yes. Yeah, please. Litigation of rights. That's it. Sorry, it's a technique. काफी पार्ट में लोग
This is my lord.
Yes, Mr. Banerjee.
My lord, section 14 order was, my lord, initially passed on. My lord, will kindly, my lord, close the brief, my lord, for the time being. I just give, my lord, the facts of the case, my lord, a bird's eye view, my lord, of the matter.
Yes.
My lord, initially a 13-2 notice was issued on 28th of September.
But the borrower.
Yes. My lord, I have been slapped upon, my lord, 5, not less than 5, my lord, 13-2 notices by the bank. My lord, in each of these notices, a different date of, my lord, NPA is indicated. My lord, an account can be, my lord, classified as NPA only once. Unless regularized, my lord, it can't be, my lord, classified NPA twice. Here, my lord, will get, my lord, as many as, not less than at least, my lord, 5 13-2 notices. Each notice indicating, my lord, a different NPA date. So, my lord, that was our first, my lord, contention before both the tribunals below, my lord, the DRT and the Learned Appellate Tribunal, that, my lord, there is an apparent error in classifying, my lord, the account as
That
NPA.
was your challenge in section 17.
Correct.
Initial section 17
Correct.
against the measures under section 13.4.
Right. Then, my lord, came an order, my lord, passed by the magistrate under section 14 on 6th of October 2023. My lord will kindly get that order at page 162. My lord, once the order under section 14, my lord, was passed.
162.
162.
Yes.
My lord, in the first volume. My lord, this order.
This is the order under section 14.
14. My lord, this order was then followed by, my lord, a second section 14 order by the same magistrate on the same application.
Where is that?
168.
This is the first section 14 order.
Correct. Then, my lord,
The
comes
second section 14
page
order.
168. My lord, one of our contentions before, my lord, the learned tribunals below was.
Why two section 14
Yes,
orders?
he says that, my lord, there was a mistake in the first order. I am rectifying that mistakes. Rather, my lord, plurally.
What was the nature of the mistake?
My lord, who is to be appointed as, my lord, the officer concerned to take possession. And the principal direction, my lord, that was, my lord, altered.
No, Banerjee, is it not, sir, please take your seat. Is it not ministerial job? Let us assume that there are some mistakes in the order, or an order was passed and or there is some mistake in the ordering part or the operative part of the order. The authority which passes the order is functus officio, cannot correct even those clerical or typographical errors.
My lord, our submission before a lordship will be that based on certain decisions. But here, if my lord just have a, my lord, quick glance at page 168, he is not even saying that he is rectifying the mistake. My lord, he is passing the order de novo. Kindly just have a look at the language of 168. It starts from the beginning, my lord, till the end. As if, my lord, he were considering this, my lord, for the first time.
Accepting that another order has been passed, what is the effective change in the second order?
Effective change, my lord, the description of
Mr.
the.
Banerjee, there are two things. One,
yes.
Let us assume an order has been passed.
Yes, my
what
lord.
is usually being done? You are mentioning, look, there is certain typographical errors, something has been missed
Usually,
out.
my lords will indicate the first order and then says
Yes.
this will.
But what is the effect? This should be treated as a part of that order, or this should be incorporated in that order.
That is what has not been, what has not happened here.
So if it amounts to a separate order, fresh
Merging
order,
with the first order.
yes. First order, those mistakes rectified, anything missed out incorporated, or anything in addition which is to be left out is left out.
Bow down to your lord.
So, what is the
Corrections get merged in the first order and the
What
first
is
order survives.
what is the effective change in the second order from that of the first order?
Kindly take, my lord, these two orders side by side. First,
Please give me the change. What is the
Yes.
effective change?
My lord, may I also show the changes? My lord, page 164 and 170. Kindly take this, my lord, two pages.
170 and 164, yes.
Right. My lord, the paragraph at, my lord, towards the middle of page 164, fourth line from the bottom of that paragraph towards the right hand side. My
Yes.
lord will get, my lord, a name, Srimati Mohua Bandopadhyay, WBCS Executive.
Yes, yes.
Now, my lord will kindly come to page 170. Same place, my lord, the name of some other person is appearing.
Yes. So this is one change.
Yes.
The other portions is same.
My lord, there is one more change. My lord, that is also, my lord, to the same effect in the next paragraph, my lord, third line.
Next paragraph, that is the last paragraph, Mr.
My lord, late photostat copy is the one-liner paragraph.
Yes, yes.
Immediately above that, my lord, there is another paragraph starting like a recital. Where, my lord, in the third line, the name of the same
The name
person.
of Mohua Bandopadhyay in that paragraph.
Yes. No. My lord, name of Mohua Bandopadhyay is appearing in two paragraphs at page.
Oh, sorry, I've got that in the last paragraph.
Oh, my lord, then my lord, the paragraph immediately preceding the last paragraph, my lord, fourth last line of that paragraph.
Oh, sorry, yes.
Towards the right hand side.
Yes, yes, so this was changed in page 170.
Right.
Yes.
Right.
And this was also changed in the last paragraph as well.
Correct.
And what is the other change?
But these are the two changes. Well, same
The
change
name of a
twice.
same person has been changed in two places.
Correct. My lord,
What is the reasons for this change?
that my lord, he is to explain. He is to explain that, my lord, we are not aware of. Then
She was transferred.
Transferred.
Yes, one. And
Ready,
the
man,
thing is
ready.
that the police station also changed because in previous order, in
Yes,
place
Mr. Banerjee, what are the decisions you are trying to rely upon?
my lord, before I rely on those decisions, my lord, on the facts, my lord, may I assist your
These are
lordship.
the two changes which you have said.
And my lord, this order is also otherwise, my lord, this is word by word same, word for word same, my lord, verbatim reproduction. And my lord, police station has, I'm my lord, thankful to my learned friend, that has also got changed. If my lord kindly turns to page 164.
So, the police station was
Because
the name
of
of
the
the
situs
police
of the
station.
property.
No.
Because of the situs of the property,
Yes.
wrong police station was indicated in the first order. My lord, that
No,
was altered
there
in the.
is the reason due to change of the area of the police station, or in the order there was a mistake in mentioning the police station.
He says
there
miss-
may be two things. Mr. Banerjee,
There was no
initially when
change
the
in the
proceeding-
no. There was no change in the name of the police station, but
or
because of the
area
situs of the
operation
property,
police station, there was also no change. There
no,
was no change in the extension of the
no. The
area.
territorial jurisdiction of the police station also did not get changed. My lord, the first police station indicated in the first order did not have territorial jurisdiction over the property. So, my lord, in the second order, my lord, a different police station was named, who, according to the magistrate, was having, my lord, territorial jurisdiction over the property.
Sir, you will be getting your chance, please. Yes. Yes,
Now,
Mr. Banerjee.
my lord, this is one. My lord, we say once he becomes functus officio, my lord, he cannot touch his order.
Sir, you can take your seat. Please be seated. Yes.
That's my lord, number one. Number two, my lord, there new decisions, my lord, have now come. My lord, I'll assist your lordship with all those decisions, which say that, my lord, initially, section 14 magistrate was, my lord, treated as an administrative authority. My lord, he had no duty, my lord, to look into the facts of the case, the correctness, my lord, of the statements made in the section 14 application. Now, my lord, law has changed. Even, my lord, there is an amendment in the 2002 Act. Now, my lord, one has to file an application, my lord, supported by an affidavit. But the reason is the magistrate now has, my lord, a duty to see, my lord, to check the, my lord, correctness of the statements made in the application. Suppose, my lord, bank says
those procedural steps have been taken
No.
here. Affidavits have not been.
affidavit has been filed saying, my lord, incorrect facts which are belied, my lord, on the face of the record, which have been taken, my lord, sacrosanct by the magistrate without, my lord, undertaking any exercise.
Mr. Banerjee, there are two things.
Yes.
On merits, are you challenging, or on this issue that he has become functus officio? He cannot.
Both. My lord, if my lord is not ultimately with us, my lord, on the point of functus officio, then, my lord, I can immediately demonstrate that the order.
But did you argue on the points of merits before either of the two tribunals?
My lord, those are borne out of record.
No. Mr. Banerjee, if you have not raised those points, if you have chosen to take only on one point before the two tribunals, why shall I allow you to raise on merits before this court?
That, my lord, I need to check once whether, my lord, in particular, my lord,
From the orders, it will be apparent.
Order does not record, my lord, everything, my lord, with the deepest of respect.
Mr. Banerjee, then you have to approach that forum, saying that I have
follow.
raised those other points,
Follow.
not taken care of, not recorded. This court cannot interfere with on that ground.
No, I follow.
So the records, I have to accept
With the
the recordings
application,
in the
Will-
records of the tribunal. as
But the
recorded.
application, my lord, does indicate some, my lord,
Maybe Mr.
mistakes
Banerjee, you may take many points.
in
You
the
may raise,
application.
yes, many grounds.
Could not
But
have
at the
urged,
time of
might
yes,
not have urged that.
yes, you have pressed, you may have pressed, you may have taken 10 grounds in your application. You have ultimately asked or pressed 2 points. So the court will consider only 2 points. The court do not have a duty to deal with the other 8 points, which you may have taken in your application as your grounds.
That, my lord, I will check once. My lord, so far as my recollection goes, my lord, none of these orders, my lord, deal with the factual aspects of the matter.
So if it is
My lord, I
only
was
on
on
the one
perversity.
issue,
I was on perversity because, my lord, section 14 order, my lord,
that you
is
cannot,
completely based on,
Mr.
my lord,
Banerjee,
mistaken
if
facts.
the learned tribunal as well as the appellate tribunal did not, or you did not, on the other way, you have not raised those points on merits.
That, my lord, I will
That
check
cannot be
once.
reopened here because I cannot be a first court on facts.
May I, my lord, put this question to myself, my lord, as a learning, my lord, procedure. My lord, if I can satisfy my lord's conscience today, that, my lord, the order is based on completely mistaken series of facts. My lord, the loan sanction amount.
And under Article 227, those can be gone into, Mr. Banerjee.
Now,
if
my lord,
not
it's a
raised.
little widened.
No.
Scope is a little widened, my lord.
227 scope has been widened. It's wide. I'm not disputing that.
Yes.
But can you enlarge the scope in 227?
Beyond the four corners of the application.
Not the application, the points raised. Points raised.
I'll do
not
a
the
little research on this, my lord. I'll do a little research on
not the
this.
points raised.
My lord, I should have
Because
anticipated this. My lord,
if you can show, yes, you have raised that point, but non-consideration is a totally different thing altogether. But if you cannot satisfy me from the orders that you have raised those points, then you cannot be allowed to raise other points other than which you have pressed in the application or you have pressed at the time of hearing.
But I follow. My lord, the difficulty is today, my lord, both the orders, because my lord, those were only the two corrections made. My lord, if I call them corrections, we do not call them corrections because, my lord, that's a de novo order. My lord, passed, my lord, afresh altogether. My lord, whether it is, my lord, a correction or not, my lord, we will make our submissions on that. But the difficulty, practical difficulty would be otherwise. The property is also, my lord, wrongly mentioned in the order.
Then they will get a wrong property, not your property. Let them execute that. You will not be affected by that. If it has been wrongly mentioned, they will take a possession of a wrong property, not your property. You are saved by that. Try to take advantage of that.
No, the
Why are you
premises
challenging
number,
that?
my lord, matches. Premises number matches.
Then what
My lord,
is matching?
the extent of the property is, my lord, wrongly
Extent is
described.
more or less.
No, it doesn't say so. My lord, it's a, my lord, multi-storied building. Number of floors, my lord, are wrongly indicated in the order. Now, my lord, which floor they can, which floor they cannot. Again, my lord, there would be an ambiguity. My lord, if I, my lord, give up my challenge to this, my lord, section 14 order and allow this section 14 order to remain as it stands today, then, my lord, this is ambiguous.
But you have allowed that to stand.
No, my lord,
You
I have
challenged on the ground of that.
That, my lord, I will check once. That, my lord, I will check once.
Because it apparently you have not raised other points. As I was cursorily going through when your brief, fortunately that your brief arrived,
scanning brief.
your brief arrived a bit late, fortunately.
My lord,
So
unfortunately for me.
I could go through the orders of
And
the
my lord,
appellate
one more thing, I
tribunal.
just
It
indicate,
is
my lord,
only on the decisions as well as the submissions.
my lord, I also
only
indicate
on
third point. My lord, the order was passed long after the application having been filed, while, my lord, the statute, my lord, prescribes a time period. Now, initially, my lord, the view was that, my lord, these are all directory, my lord, to expedite the affair and all.
No, which period?
My lord, within a month, my lord, from the date of the application being put in, the magistrate is under an statutory obligation, my lord, to pass the order and dispose of the matter. My lord, he can extend the time, my lord, for a particular period. Beyond that, statute does not give him any, my lord, chance. My lord, there are old.
What will happen thereafter?
Yes, my lord, there are old judgments which say that, my lord, the magistrate does not, my lord, lose jurisdiction.
Yes.
Now, my lord, the Supreme Court has said that, my lord, time, as indicated in section 14, is of the essence of the statute.
Yes.
So, my lord, if
possession will not be, section 14 will be rendered ocious
yes,
only because of that particular officer.
that's how, my lord, That's how, my lord, I have read the Supreme
Mr.
Court judgment.
Banerjee, that is very difficult.
My lord, that's how, my lord, once Apex Court says it, my lord, subject to my
Cannot
limitation of
be-
understanding.
It says that cannot be exercised. Section 14 power goes. Not even by a fresh
It says,
application.
my lord, it's of the essence of the
That
statute.
is a different thing. Nobody
That's,
is
my lord, the
disputing
language
that.
used.
Nobody is disputing that.
My lord, if
That
time is of the
observation-
essence of a contract and, my lord, the contract is breached and, my lord, there is no mutual, my lord, extension,
Yes.
then, my lord, possibly.
Mr. Banerjee, don't correlate that with this, because this, as per the statute, some authority has to do something.
Within,
For the inaction of an authority, a right of a party will go.
he can file a second, my lord, section 14 application. He is not debarred from doing that.
All right. So if he does so, then the other way around,
But
he can again modify
correct,
that.
but not on the self-same application, possibly. My lord, will
Then,
come,
then it can be modified, Mr. Banerjee.
Right, for
If
a
a second
borrower, it's always
application
will an uphill task, and when will a
But a
borrower
second
faces your
application is
lordship,
maintainable,
it is an
so
uphill
more
task.
so a second view can be taken.
Right, I'll do a little more research on this and come back. Today, Milord, I'm not troubling your lordship. Milord,
I'm not least troubled, provided you
but
have
I'm
other,
troubled.
yes, you have other businesses elsewhere. So I do not have any other business. I only have.
But
these
I must
businesses.
meet the queries of your lordship, Milord. A little more research on this. Come back. Milord, may it be in the next week, Milord. After 25th, I would be traveling, Milord, all this way. Milord, on professional
You
purpose,
are
Milord,
here
not on
this
personal
week, Mr.
purpose.
Banerjee.
I'm sorry, Milord.
You are here. You are the only advocate who is here in this week in Calcutta.
No, Milord, mine would be on professional purpose, not on personal purpose. Milord, I'm not that rich, Milord. I can spend money, Milord, every time.
Yes. When do you want?
I am just pointing out.
Mr. Banerjee, you said after 25th.
Yes, Milord, anything
Milord,
after.
they are enjoying more than 4 crores. 4 crores of amount. They are enjoying without paying any amount. Public money.
My learned friend is a little incorrect, Milord. We have been paying, we have documents to show that.
But my lord,
And that is why, Milord, every time, Milord, NPA date gets changed. Every time.
The
that is not the issue, my lord.
That is an issue.
Whether the order passed
Mr.
by
Banerjee commences his argument. Mr. Banerjee, learned advocate appealing for the petitioner, commences his argument. But have you filed your affidavit in opposition?
No, my lord. Mr. Aravind Chatterjee, senior advocate.
Oh, you are led by Mr. Chatterjee. So there was I think there was a liberty granted. You do not want to file any affidavit.
Yes, I do not want to file any evidence because all the documents belongs to record, my lord.
All right.
I just having paragraph number 5 of the judgment, where that the applicant had raised 2 points before the honor
Paragraph 13 of the
judgment.
Appellate tribunal's
Judgment
decision.
passed by DL.
paragraph
Page number 3, my lord, the judgment.
Yes, page number 3, paragraph number
5, my lord. This is our
5.
point. This is our point. The whether, because as per the deed, when the property was purchased, the property belongs to the Tiljala police station as per deed. Nowadays,
Belongs
Calcutta
to Tiljala police station.
yes, as per deed. Nowadays, the property belongs to the Progati Moidan police station.
So when the deed was registered, it
Property
fell within
belongs
the
to me.
jurisdiction of Tiljala. Now it's Pragati Moidan. It has been changed subsequently.
Yes, ma'am.
This has to be because Tiljala was the Pragati Moidan has come up bifurcating from
Please, Milord,
Tiljala.
I was wondering whether it is my learned friend's case that, Milord, in between, Milord, these 2 orders, Milord, the police station got changed. Milord, I'm sure.
Not in between, not these 2 orders. First
Not
is
be
the-
Mr. Banerjee may not be between these 2 orders.
Milord, when the first order was passed, Milord, the same police station was having territorial jurisdiction over the property who is named after in the second order.
All right. Yes, paragraph 5 prima facie shows not only paragraph 5, the other portions.
The appellate tribunal's discussion is only on the issue of functus officio. Milord, I will just check, Milord, whether it was argued, Milord, in the learned tribunal
Well,
below.
please come to paragraph number 17, turning page number 10 of the inner page number 10 of the judgment.
Yes, yes, that I have seen.
This is the subject matter of this case.
The whole controversy.
Yes, ma'am.
These are the 2 points which have been framed by the appellate tribunal.
Appears to be so, my lord. I will just check once.
Kyola?
And I will also, my lord, do a research on that.
But could not conclude due to paucity of
I stayed here for this matter. Only
52.
50. Upgraded motion, second item.
Upgraded motion, you ask your juniors to be ready, Mr. Banerjee, Mr. Laidi.
On the last
Difficult.
occasion, the
Adjournment, it will be adjourned, but
only one, not this week, not tomorrow. On the last,
is not
last
reached.
level advocate for the bank had sought for that.
You are a senior advocate, Mr. Lahiri. So you are assisted by a battery of juniors. You are assisted by a battery of juniors.
Everyone
And they are fully ready.
Basically, I stayed today, but I thought that Rosh will be taken up this upgraded motions from 2 p.m.
I could because the some fixed matters 4 p.m. You are alleging that these matters are not being taken up.
I do not follow that. Tomorrow I will kindly.
Not you personally.
Everyone has have to go and join.
Tomorrow everyone will join. 52. Item number 52. ওটা কালকে not this week করে রাখুন নাকি not today করে রাখলেও তো হবে কালকে not today করে রাখুন. Yes. Which item?
146.
146.
Upgraded ones. Instead of 4 p.m., your lordship takes up from 3 p.m.
Look, Mr. Lahiri has just now alleged that my 52 has not been reached.
You have not alleged it.
52, it was upgraded. He waited the entire day for item number 52. And that did not reach.
We also waited.
That is his allegation.
No, that's not my allegation. I thought that lordship
Submission.
would be taking that from
Submission.
I thought that lordship would be taking up from upgraded. From
Any indication ছিল নাকি?
No, that's no indication. That's no indication. There was a practice.
Tomorrow I can take up these upgraded matters from 2 p.m. Tomorrow, if you want, I can take up. No, not for your matter. If all of you want upgraded matters tomorrow from 2 p.m., I can take up that.
I don't get that. There's some matters will be over, madam.
আসুন দেখুন।